Yes, Your Honor.
All right. My understanding is that there are two attorneys currently that may be able to take this case, but we don't have confirmation of that as of today. I would like to set it over 1 week for review on the 3rd, unless there's another suggestion by, I guess I would defer to Ms. Ward.
No, Your Honor. I was just, the two things I was going to ask about today were just the time frame for obtaining an attorney. As Your Honor knows, this was first heard in early July, so it's been about 3 months, and we're just nervous that by default we're going to be looking at a trustee sale because there's not enough time to take any other action. Also, just wondering if Mr. Couch has any information he can share about any sort of plan he has in terms of trying to keep the house out of foreclosure, because the only reason this motion is pending is because we don't want it to go into foreclosure and end up at a trustee sale. So if he can shed any light on that, that would be great.
Yes, absolutely, Your Honor. I do have a plan for that. This motion has been hindering that quite a bit because the trustee sale is November 3rd. I have to make up the arrears by the 23rd of October, which I can do. But the problem is with this potential taking the property out of my hands, my investors, if you will, are very, they want to know that this isn't going to happen. We're talking, the petitioner is saying we need to take control of this to sell it, but we're talking less than a month now. That's just not even conceivable. So I would suggest that we just deny this motion and let me proceed forward to making sure that the property is secure. I have a great interest in doing that. Absolutely no reason to let it go to a trustee sale. And then that also will preserve anything for the petitioner. So this is kind of, I would say, almost in the, absurd that we would be talking about trying to, hinder me from saving the property to turn it over to the petitioner who has no time to do what she's planning on doing. There's no conceivable way to list the property, find a buyer, sell it, and to be able to satisfy the trustee. That it just, I don't know why we're still talking about this, but I would like you just to deny the motion, let me go ahead and secure the property, get it out of foreclosure, and then both parties will be preserved, if you will.
I guess I didn't really hear the...
Yeah, I didn't hear an answer to the question. I guess a couple things, Mr. Couch. One, you asked to be represented by an attorney, so I'm not going to...
Yes.
So I'm not going to, entertain any motions that you make on your own behalf, since we're pending an attorney appointment for you. So I'm not going to dismiss the motion. Second, I don't know that this request is hindering your ability to do anything, frankly, since this has been, the trustee sale has been in place since at least July of 2023. So clearly you haven't done anything to make up that money in the meantime. And we've had 2 or 3 hearings. So, and I understand that this is probably overwhelming. That's why we're getting you an attorney. But clearly, if there's a way for you to make up any arrears and get this out of a trustee sale, it's to everyone's benefit. So if you can do that, you should not hesitate to do that. I don't think. I am going to set this over 1 week. I'm not dismissing the motion. We'll review this on the 3rd. If we get, I don't want to waste people's time, and I understand that this is a very time-sensitive issue. If we get an attorney on board and they request a review on the 10th, just to have time to actually complete a motion on the 10th, I'm going to ask our administrative staff to work with Ms. Ward and Mr. Couch and whomever that counsel is to see if we can renote it on the 10th and strike the 3rd, just to save everybody the time and expenditure of having to show up here again if we're just going to set it over. But right now, not knowing if one of those two folks is going to be able to take the case. I want to review it next week because I am aware of the sensitivity and the timeliness factor here. So we'll set this over 1 week to October 3rd at 1 p.m.
Thank you, Your Honor.
Review those orders. Did not receive any objections as of yesterday afternoon. Looks like Mr. Cruz is here. Have you been able to review those orders, Mr. Cruz?
Yeah, wasn't very, obviously I'm not in the order of court, so I don't know how this fully works. I do have like 2 slight changes I'd like to make in the orders, but beyond that, I was perfectly fine with them.
What are those 2 things?
So with my other half, she seems very throughout the courts on the pickup location. I have moved up to Tootle. That's beyond out of Longview. It's about a 50-minute drive for me to her. It's about a 5-minute drive for her to the pickup location. I'd like that changed more to halfway. I'm shooting for maybe far into Castle Rock if that's providable. So it's more half and half. And then working on the summer schedule. I know we're coming into wintertime. It's kind of a ways out there. I'd like to change that, our previous every other weekend schedule, to potentially every week or every weekend, so I can have more time with Lila. And being on the school paperwork as well. I'd like to know how she's doing at school. I'd like to be at her conferences.
Miss Bliss, I understand you're covering for Mr. Zandy, and obviously we didn't get these issues before right now. I know that there is joint decision-making for healthcare, limited decision-making from Miss Cruz on school and education. I don't think that there's anything that would limit his ability to be notified of what's going on at school as far as like grades, any issue with that.
I don't have any objection to that. I think obviously he's a named parent. He should have access to the records, and I don't have anything in my notes saying otherwise. So I guess I would defer to the court on that issue.
Okay. And I don't see anything in these orders that doesn't allow that either. So,
Correct.
Mr. Cruz, you should be able to, you should be a listed parent on any registration that she has in school. You should be able to get access. I know a lot of them have online portals and even applications for your phone that you can keep track of attendance and school functions and all that. So there's nothing that I'm seeing in this order that limits that, and you should have access to all that. So as to the pickup and drop off location, I'm not making that change at this point. If the parties do come to an agreement to change that pickup and drop off location, I'm fine with that, but I'm not going to make that big of a change at this point. And summer schedule, this is a temporary parenting plan. We are pretty far from summer schedule. I'm going to enter the parenting plan as proposed at this point in time, and that can be renewed. That motion can be renewed. So that means you can bring it back at any point. If we get to, we're approaching summer and things are going well and you want to readdress that, you're more than welcome to. But at this point, summer's over. We're back in school. So I'm going to just enter the order as presented.
All right, thank you.
All right, Miss Holder, I think, popped up saying that she had maybe a quick matter.
Yes, Your Honor. This is in the case of Madston.
All right.
In this one, my client was not served properly. She was not served until it was filed on the 14th, served on the 13th. Our response would have been due on the 12th. So we are asking that this case be set over. Additionally, we are filing something to modify the parenting plan, and we already have a court date for that on October 24th. So we would ask that this case be continued until then and all the issues be heard together.
All right. Is Casey Maza here?
Yes. Yes, I'm here.
All right. Were you able to hear Miss Holder?
Yes.
Okay. So I did note when I reviewed that there was likely some potential issues with service given the time frame of service. And she's indicating that there is a date for, did you say October 24th already?
That is correct, Your Honor.
So about three weeks out from now, maybe 4 weeks out from now.
I have not served nothing for that.
We just filed it today, Your Honor.
Nice. So
okay, and the stuff I was served to her, I mean, she's just denying it. I'm giving it to the sheriffs, and they're showing up at her house, and she's not answering the door. not going to work. She's not. The cops are going there to try to get to her. I had her personally served 2 times. She had the papers in her hand twice and would not accept them and threw them back on the ground. And one time threw them back in my other server's face and laughed at him and said she's not taking them. So I mean, it's been a fight the whole time. So she was served plenty of notice. A couple times.
I appreciate the frustration and the efforts that were put into this, and I understand the underlying allegations. When I reviewed it, I did note a couple things, and one of the things I noted is that timeliness of service appears to be an issue. So the final declaration that was entered and the time frame would allow them for additional service. I am fine to put it on sooner than October 24th, but it sounds like they've noted another issue on for October 24th. Mr. Mazza, do you want this set before then, or are you willing to set this to the 24th on the same date?
Oh, the 24th is fine with me.
Okay. Clearly, and this is just kind of this is just going to be a statement for the parties. Some of the allegations here are concerning you're both parents to a child in common, and hopefully there won't be behavior that impedes the other parent's ability to parent and be involved in their child's life. So I'll grant the continuance, and we'll set this to October 24, 2023 at 1 o'clock p.m.
I think it's going to be quick.
Thank you, Your Honor.
Sure.
Number
Thank
10
you.
and 11, it's a state v. Ornelas and Martinez. Ms. Ornelas has not filed a response. And there was proper service.
I did review this. I did not see a response filed. I do see that there was a waiver of exclusive jurisdiction out of the dependency that was done so the dad could specifically file this petition. Did look at essentially the rules that were in place for the dependency and the request in the family law order, that all of those things match. Do we have Miss Ornelas is present? And I did not, as of, well, there's still nothing in the file today. And when I last reviewed yesterday evening, there was nothing, no response. So given that I have reviewed everything, I will sign off on that temporary family law order and parenting plan as proposed.
I have will be sending over a child support order that's in line with the child support worksheets we filed. I just needed to get my client's signature on that, and I was not sure if Ms. Ornelas was going to show up. So I'll be presenting that order later today.
Jessica
Okay.
Olson, let's try
All right,
this again.
thank
If you want to unmute, and hopefully we'll be able to hear you this time. Still looks like you're muted. I'm going to ask you to unmute. Sometimes that puts a,
Okay, is it working?
yes, I can hear you. Thank you.
Perfect. Thank you.
Success. All right. Mr. Baldwin,
Yes, Your Honor.
you're going to have to forgive me because I
okay.
forgot what the issue was that you raised.
Well, I'm asking to, yes, Your Honor, I'm asking to strike. There was a docket notice filed with a proposed parenting plan to set the residential schedule and finalize the parenting plan. This is a temporary by which the parties have been operating since, I believe, 2019. It looks like Ms. Olson filed and docketed on for what was ostensibly meant to be a negotiation. The only declaration is that she's proposing to him to have the residential schedule and final parenting plan set. There's no motion. She's not asking to modify. She's not asking for a temporary order. She put on to finalize. That's not the proper method for that. There's no motion before the court, so it should be stricken. I'd ask the court to reserve on fees. There's other hearings currently set, and I'd like to address everything at once as far as fees would go, but if there's anything before the court to decide today.
And we are on for October 10th properly for a contempt. Is that correct? A motion?
I think the 24th for contempts. I believe she filed a motion for modifying child support that's on for the 10th.
Yeah, I tried to put it on for today, but they said that I didn't do it in time or something. I thought we could all do it together. But the court clerk gave me all of the papers saying, like, they gave me a guideline, a checkoff list to be here today. So since we already had a parenting plan and it was finalized and then temporaried, by the respondent, Like they just told me to like refill it out and that you guys were supposed to respond by the 20th, which you guys didn't. I assume because you were just going to try and throw it out. But they said that I had all of the necessary paperwork filled out correctly.
The paperwork doesn't appear to be defunct as far as how it's filled out or what's there. But I would agree with Mr. Baldwin that there's no motion, there's no anything that's indicating anything other than the calendar notice, which says set residential schedule and finalize a parenting plan.
So yeah, I served them on August 31st with a new proposed parenting plan because our parenting plan was already finalized in 2015. And then Mr. Olson opened it again in 2019 for a temporary. And then, I got a letter that was not court, it wasn't through the courts. It was just from, Joshua Baldwin's office. And they were proposing, that I pay all this back child support. And, when our children went to live there with him, 4 years ago, he said that he would never ask me for support, and I support my daughters. I buy them whatever they want. So them trying to throw it out and strike it because I don't have a silly little piece of modification, like, one line paper. I mean, they know that why we're here, we should just, be able to do it. I mean, it's just them trying to get out of, hearing it. And, it's ridiculous. I mean, we already had a final order and he just, wanted to say that he was the custodial parent, even though they were already living there in 2019. And so he comes to the realization that it's actually not finalized. And, our son turned, 18 last year. He's 19. So now they're saying, oh, you owe all this back support if you don't agree to this, blah, blah, blah. So the October 10th calendar is for me to pay child support because I'm sick of him telling people that I don't help with $1. And, I put in there the last 6 months of, the monies that I've spent on my daughters. And so, I mean, I would just ask that we do this today. I mean, there's no reason to strike it.
If I can respond very briefly, Your Honor, as I indicated, court can't enter a final parenting plan that isn't agreed without a trial. That's what she's trying to get done here. There's no mechanism for this. She's not asking to modify on a temporary basis. It should be stricken.
I proposed to you. It was a proposed.
Okay. All right. Ms. Olson, you're not helping yourself by interrupting and being argumentative here and saying that court documents are silly little papers that we could just ignore. So that none of that's helping your argument. I'm just going to be very frank with you. There's a protocol. Just because the paperwork that you filled out was done properly doesn't mean that all the paperwork that you need was done properly. You're proposing a final parenting plan that normally would need to go through either a trial to get to, or it's agreed between the two parties. And it sounds like it's not agreed. Here's what I will do. I show that we're on for the next 4 weeks. We're on almost every week. So the 10th of October, we're on for child support. The 24th of October, we're on for a contempt. And the 31st of October, we're on for a contempt. I don't know if the two of you can agree today to maybe condense those all into one hearing so we don't have to come back 3 times in the month of October.
I'm fine with the 24th, Your Honor. I believe that's the date set for our contempt. I'll say for the court, when you get to look at the contempts, Ms. Olson is alleging a contempt based on the original final order from 2015, ignoring the superseding temporary orders from 2019. That's the basis for our contempt. I think we can respond to her as timely and we can hear it all on the 24th.
So my question is, am I allowed to speak?
Mm-hmm.
So I served them with the court clerk told me to turn in the final papers a few days before this court date. So that's what I did. I sent Mr. Baldwin's office a proposed parenting plan and gave them till the 20th to respond. And they did not respond.
Because they don't have to respond to your proposed parenting plan when there's no motion before the court and there's already temporary orders. They don't have to just agree to a finalized parenting plan because you noted on the docket. That's not how it works. So we can, if you want to file a motion to amend what the temporary parenting plan is, or if you want to try to have a conversation with Mr. Baldwin and his client about coming to a final parenting plan, that's completely okay. You can't just file a final parenting plan when they're actively participating in the case and expect the court to just enter it. That's not how that works.
Right. So yeah, so the court clerks, you know, said that they gave
They
me
are,
all
court clerks
all-
aren't attorneys, so they
Right.
can't advise you. They can tell you which paperwork you need for what you're trying to do. That's what they
yeah,
can.
which they did. So conveniently, they, you know, forgot my temporary child support order and told me that didn't tell me that I needed to fill out that motion. So-
Okay, again, Miss Olson, you're not helping yourself by throwing the clerks under the bus. They tried to help you. They're not attorneys. They're not required to do anything but give you the paperwork and show you how to file things. So here's what I'm going to do. I'm going to set, if there's no argument, are you okay, Miss Olson, with the child support modification request going to the 24th of
That's
October? All right. I'm going to strike the 10th of October and I'm going to strike the 31st of October. Ask that the clerk condense all the contempts and the child support modification so we can hear them all on the same day on October 24th. If there's any responses that are needed from either side based on any of those things, you should comply with the statutory guidelines.
Yes, Your Honor. With court reserve on any fees from today.
Yeah, if there's any requests, we'll hear that on the 24th.
Thank you, Judge.
The petitioner.
All right, we'll see you all
Sean
on the
McGill.
24th of October, 1 p.m. All right, and
Beth Fellows, GAL.
thank you. And do we have Luana McGill present?
Yes, Your Honor, I'm here.
All right, thank you. We are set for readiness October 10th and trial the week of October 16th. Do we either party have any issues or concerns about progressing to trial at this point?
I have some concerns, Your Honor.
Okay, go ahead.
I have asked on a couple of occasions through interrogatories for the total amount for a retirement from 10/23/99 to 3/1/21, the date that this thing was filed. I also asked for a TSP, which is thrift savings plan total from 10/23/99 to 3/1/21. Mr. McGill, here's our problem. The court's going to have to decide what date is our separation date. So he's just sending me things that he thinks are up to the day that he says we separated and not the day that the was filed. I also asked for a vehicle title and statements of payments made and total due for the Jeep Renegade. His response is that his mother bought it in 2021. That is still during our marriage. So I haven't received anything on that. And I did ask, I sent them interrogatories on January 9th, 2023, and I have still not received anything that is up to March 1st of 2023.
March 1st, 2023 or 2021?
I'm sorry, 2021.
Okay.
2021. I'm sorry.
No, that's okay. I just wanted to confirm. Ms. McLean?
Well, this is the first I'm hearing of this. I've received no communications from Ms. McGill in regards to this. I'm just looking to see what I have online. We produced supplemental discovery answers. We produced the second discovery answers on February 3rd of 2023 and provided supplemental discovery on, it looks like April 7th of 2023. I'd have to go into these files. I guess, let me look and see, because I don't remember. Bear with me just 1 minute. So it's a little difficult for me on the fly to try and address these issues. She's had 9 months to talk to me about this. I've received no communications from her in regards to this. There's been no motions to compel filed. At least my electronic file shows that we produced answers on, let's see. It looks like we produced supplemental answers on April 12th, April 7th, February 3rd of this year. We've produced answers on February 21, 21st of 2/21/23 that included the VA information I know that we produced the retirement documentation and TSB documentation because all of that's been included in my ER 904 that was served on Ms. McGill. We had submitted voluminous answers back on October 27th of 2021. And so it looks like we've provided 1, 2, 3, 4, 5, 6 sets of discovery and supplemental discovery responses. So I'm not sure why this is a claim that's being made except for the potential attempt to prolong this trial. This matter's been set for a number of months. And at this point, I guess from my perspective, we have submitted our witness list. I do anticipate calling 4 witnesses, the guardian ad litem and my client. And I just need to confirm if, one, I've never received disclosed witnesses from Ms. McGill. I'm assuming that she's only planning on calling herself.
May I reply, Your Honor?
Yes.
I will be giving them my list, but according to the court rules, I don't have to do that until 2 weeks prior to the trial.
Well,
so she will receive those 2 weeks prior to the trial, according to the virtual courts, Zoom virtual trial policy, deadlines, and compliance.
Well, she has an obligation to comply with discovery, and my discovery request asked her to disclose witnesses, and no witnesses have ever been disclosed, lay or expert. Obviously, I would want to have the opportunity to have that discussion with my client about whether I need to depose any of these witnesses and the like. So at this point, there have been no witnesses disclosed to me.
It says on here, it says exhibit and witness list. 2 weeks prior to trial, each party is to file with the court and send to the other party a
Okay,
document.
I don't need you to quote my own our own rules, but
Okay, sorry.
if it was requested in discovery, then you need to respond to discovery requests. So without forcing Ms. McLean to look through everything, I'm tempted to set pretrial over 1 week because that's still 1 week prior to readiness, or we could pass to readiness and see where we are at that point. I'd rather have this conversation on this docket than a readiness hearing docket, though, if there's additional concerns.
Well, I still haven't here's the last thing I received from them, and it was on February the 3rd, but it's only given me the value of the TSB for December 31st, 2020, not March 1st, 2021. The same is also with the retirement fund. So I'm sure there's more thousands of dollars that they're not giving to me so that I can properly prepare. I'm ready for trial. I'm ready to go. I'm ready to get this thing done and over with. But I do need that documentation. So, and just the same with the vehicle. He said he sold it to his mother in 2021, but yet he's not giving me any titles or anything like that. I don't have the statement of how much she's paid for the vehicle. And this is all done through our marriage. But this is the problem, is the court is going to have to decide what our separation date is.
When did you request that information?
January 9th, 2023.
Okay.
And we have responded, Your Honor. I do have my discovery book here now. So we provided documentation to her on April 7th of 2023. We provided documentation on March 10 of 2023. We provided supplemental documentation on February 21 of 2023. And we provided the actual answers to discovery on February 3rd of 2023. There have been absolutely no communications as to any insufficiency of those 4 sets of responses to her second discovery request from December of 2023.
Yes, but the other documents that you sent me did not give me the supplement documents of the final amount, total amounts of his thrift savings plan and his retirement first. And also, he said that on the vehicle that it doesn't matter because it was sold to his mother during our marriage. He just refuses to give me a copy of the title and the amount of the statements.
Well, obviously, Your Honor, I'm not a mind reader. I can't know or create conflict on my own for my client. Ms. McGill needs to learn how to communicate, and she hasn't done that. So I guess since we're here, who are her witnesses that she's planning on calling, so I can decide potentially whether or not we should set this over as you suggested to next week, or if I need to potentially have more time with my client.
Ms. McGill, who are your witnesses?
I have no witnesses. This divorce is between myself and my husband. I'm not bringing anybody else to this trial.
Okay, so I don't think that we need another pretrial in light of that.
I still don't have the answers. I still don't have the total amounts of money.
So here's what I'm gonna do. I mean, I am gonna pass this to readiness. Miss McGill, you need to reach out to Miss McLean with specific requests of what, if it sounds to me like you're just asking for 2 additional months of the TSP and the retirement account, and then some information about the car that's sold. Whatever you are asking specifically, reach out to her, request it, and then we will address this at readiness, which is set for the 10th at 11:30 a.m. If all parties are ready to go, then we'll get it set at that point in time.
So, Your Honor, the only thing that I would note is that my recollection, and I don't know if I've got that portion. I believe TSP documents, much like 401ks, are produced on a quarterly basis, and I believe we produced the last quarter, which would have encompassed the dates that she had requested. So December 31 of 2020 would have been the last quarter. So, and then we did produce all of the FERS documentation. We produced that to her former attorney back on March 22 of 2022, and provided service computation dates of 1998, 2010, and bear with me. Well, it was run on February 16th of 2022. So I assume that their calculation of incomes would have run through that date.
22 or 23?
22. These parties separated. They actually separated in 2010. This action was filed in, well, what's our cause number? 2021. Yep. It was filed in 2021. I don't have all of my files here, but my petition, at least on my end, is dated. Oh, actually, he must have filed pro se.
Yes, and we didn't separate until March 1st of 2021.
And that's disputed. But
yes, that's why the court's got to make it up.
In any event, the report that we produced from FERS is dated February 16 of 2022, a year later. So I'm not certain why we're having this discussion.
Because they gave me the amounts to 2011, not to 2021.
Well, you indicated that it was through December 31st, 2020 that you got responses, not March 1st, 2021.
Correct.
So not 2010.
2011 is where they gave me the amount for the retirement fund. I got the 2020 for the thrift savings plan.
Okay. I request what you think that you need, and we'll be back at readiness on the 10th. And if you at that point feel like you haven't received what you needed, then you can make a request for something at that point. To me, it sounds as though there's a pretty thorough exchange of information. And if you're concerned about something that the judge may not have, I'm assuming the judge will ask for whatever information that's needed at the time of trial. So I'm gonna pass this to readiness, make any requests specifically in writing to Ms. McLean as soon as possible. So if there is anything that is missing, that can be addressed as quickly as possible.
May I ask a question?
Yes.
Do I do that formally through the court, or I just send her an email?
Just send her an email.
Okay, thank you.
Okay, good luck.
And then do we know now, or will that be at the time of readiness, whether or not this would be by Zoom, hybrid, or in person?
That will be determined at readiness. And I
Okay.
do have it listed at a 2-day trial. If that changes, make sure to let the judicial officer on that readiness docket know.
I still anticipate it'll be 2 days.
Okay.
It will
perfect.
be.
We were here on the 20.
All right.
Thank you.
Thank you.
2nd of August. Mr. Ibarra requested time to retain an attorney and indicated that he was going to be making payments for childcare. There was concern over losing the child care provider. He indicated that he would pay the child care provider, and it was set over today to see if he retained counsel and that if those payments were made. So where are we at? I will say nothing's been filed, so I'm assuming Mr. Ibarra is still representing himself. And
Yes, Your Honor. Can you hear me?
I can.
Yes. So I've been paying, kept current as the time that we have talked. And when I went in, the 2 days after that, they shut our job down without permits. So I went and took a different job, which I'm doing right now. And I paid everything up till then. I have another check for $600 to give her today. And then next week, I told her by next Friday, I will be current. But I can't get my lawyer until I get everything current up with this, because this is for a whole different matter besides this right now. So if I can have till next Friday, I can have that all paid off and be current with all that. And then I guess after this is all said and done with, I can retain a lawyer, then get done what I want to get done.
And Mr. Ibarra, by next Friday, do you mean October 6th next Friday? Like a week from Friday?
Yes.
Okay.
Because I get paid Wednesday and Friday. And that way I pay the rest of the $300 on that Friday, and I'll be current.
Okay. Ms. Bliss?
And Your Honor, that's not the information I have. An email from my client outlining everything, and I'm more than happy to provide this to the court as well, indicates he's made 2 payments since this has been brought before the court, and there's still substantial arrears owed. At this point, I mean, depending on what Your Honor wants to do, he hasn't filed a response to our motion. We've set it over for over a month for him to retain counsel. While I understand that finding an attorney in this county today especially is difficult, but a response could have been filed and simply has not. So I'm asking the court to enter my order as it's been presented. If Your Honor wants to set it over, I just ask that you reserve on additional attorney's fees, given that we've been in court twice now for continuous set overs.
All right, here's what I'm willing to do. I am aware of the struggle to get an attorney. I don't know if Mr. Ibarra is, it sounds like he may be trying to prioritize getting the payments made versus getting an attorney. This will not be indefinitely set over. If he has a plan and hopes that by the 6th, everything will be paid, I want proof of that. I'm going to set this to the 10th of October at 1 p.m. I'm going to ask, I'm going to keep the order, the contempt hearing order that we have here. And Mr. Ibarra, essentially, I will allow the fees and penalties will be reserved. So depending on what you do in the next 2 weeks will depend on what this order indicates. There's clearly some strong showing that you're in contempt. We haven't officially made that finding or entered any judgment yet. I want to promote your plan and hope that gets everything caught up. If on the 10th of October it is not, then you likely will be found in contempt and there'll be additional judgments entered against you. Do you understand all that?
Yes, I do.
Okay. So I expect a filing from you, Mr. Ibarra, and it doesn't have to be anything fancy, but you come into the courthouse and ask the clerks to help you file whatever you have showing all the payments that you've made since we came to court first on the August 22nd date. So
Okay.
all payments from August 22nd through October 10th, get those filed. And if you could provide a copy of that, Ms. Bliss, are you willing to accept that via email or? So
Absolutely.
if you could email Ms. Bliss what you're filing and get that done, I'm fine with it coming in as late as the 9th of October. So if you're getting paid on the 6th, I'd love it to be filed on the 6th, but I'll take it until the 9th and then we'll review it the 10th at 1 p.m.
Okay. And I guess, how do I get her email? I don't got her email. Can I just give a call to her office and get that?
That's fine, Mr. Barr. I believe that we've corresponded with you via email before, but if you don't have it, just give my office a call. That number's on the footer and they can give you my email address.
Okay, is that Aaron? Is that the same one?
Yes.
Okay, I got it then.
Perfect.
All right,
Right.
thank you.
Thank you.
Your Honor,
Okay.
Christine Dow representing the petitioner Jamie Lucas, formerly known as Jamie Bobbitt.
Couple of things that we're dealing with today. There was an adequate cause motion and request for temporary orders. Let me just. And if my memory is, I don't know, it's questionable today, but I believe there was essentially an agreement on adequate cause. Is that correct?
Yes, Your Honor.
Okay. Guess maybe it's better than I thought. All right. And I don't know who the initial moving party is, so whomever wants to begin any comments or argument.
My client was the moving party, so I can proceed. Megan Gilmore on behalf of the respondent, Chad Bobbitt. Just quickly going through the issues that were agreed from our original motion. I do believe it's agreed to terminate the right of first refusal requirement, the mediation requirement. We also have filed an updated proposed temporary parenting plan where my client has stipulated and agreed to modify the Christmas language, the vacation language. We've added that the parties shall communicate via the Talking Parents app. We've added language that activities shouldn't infringe on the other parent's time. And we've added language that children should be allowed to attend out-of-state related topics. I then can proceed with some information regarding the contested issues. First, my client is requesting that the children are exchanged on Mondays after school rather than Sundays. Due to mother's constant harassment and just need to control my client, these parties have had constant conflict. I've provided about 40 pages of text messages, but I'm telling you, I've gone through thousands and thousands of pages of this constant conflict between these parties, trying to both interpret the parenting plan as well as just simply exchange the children. These children feel the tension and shouldn't be subject to the conflict of the parties. My client is simply just looking to eliminate conflict and communication that's not necessary for immediate issues pertaining to the children, and he believes that's in the best interest of the children moving forward. The exchange issue, I believe, is twofold, as mother is asking the court to deny my client's request based on the exchange of the children's personal property on a weekly basis. These parties in this case have been divorced since 2017 and have been exercising a joint residential schedule for over 7 years. My client explains in his declaration that mother abuses the provisions under the current order that require the parties to share the children's personal property. Frankly, again, as a way to maintain control over my client. Again, I've only supplied just an example of the text messages that are happening on a regular basis. But again, there's thousands of messages where mother seeks for compensation of one-half of $12.96 for notebooks, $3.78 for graph paper, and $17.20 for flip-flops. And it just simply goes on and on and on. Again, this is just simply petty daily conversations that don't need to take place. As referenced within the messages, my client is just complying with her demands to avoid fighting, but he doesn't want to continue to keep doing this as it ruins their co-parenting relationship, and in turn, the children are being put in the middle. The children, frankly, have been living out of suitcases for 7 years since this final order was entered, and it must stop. Both parents should supply the basic necessities for these children, and there should be no need to be transferring a vast majority of their just everyday items. My client explains to the court that he acknowledges that these items are the items of the children. So if they want to take, small items back and forth, that's more than reasonable. However, they shouldn't be transferring every single item, clothing, toiletries, etc., on a daily basis. Therefore, if the court eliminates this language, there should be no need or issue for the children to be taking all of their items from one household to another on a weekly basis, therefore eliminating the concerns of mother. Moreover, my client's proposal with Monday after school exchanges provides both parents a full weekend through Sunday rather than having to plan and stress the exchange happening on Sunday evenings. My client explained one recent incident where he wanted to go to a concert, mother refused. This is the type of situations where the children are missing out on activities or going out of town because simply they have to plan their lives around this Sunday exchange that results in constant conflict between the parties. Moreover, in the mother's recent parenting plan that she filed last week, I was on vacation. I didn't have the ability to respond to it, but she provides an exchange for Sunday at 10 p.m. I frankly don't think that proposal is in anyone's best interest, particularly the children on a Sunday 10 p.m. before school, as well as the parents that my client has to work. We do ask the court adopt our parenting plan with the Monday after school exchange with the picking up parent being responsible for transportation. I can provide additional comments or if the court has any questions, but my client is pretty detailed in his declaration in support of this. We do ask the court to adopt our holiday schedule. Again, my client explains that he was willing to tweak the Christmas and he did tweak the changes requested in the vacation. He is asking the difference of the holiday schedule that I see was my client is asking for overnights for Easter. Again, he does have family outside of the local area and he's wants to spend time with them. Under the current orders, he isn't able to because it's daytime only. We also request that there is no additional language or order for the children's birthdays. These are 15 and almost 18-year-old children. The oldest child's about to fall off the parenting plan regardless, but the proposal by mother is that each parent or non-residential parent have 2 hours of birthday time. This doesn't allow the residential parent to go out of town or do anything. Again, it just really restricts their ability to, really exercise and enjoy their time. We also don't agree to the provisions in section 12C and D within mother's proposed parenting plan. We frankly believe each parent should be responsible for getting the children to their appointments during their residential time. Again, mother tries to carve out exceptions where she is provided basically right of first refusal, where if my client directly isn't available, then she is allowed to transfer the children during the residential time. My client has a wife, they have a family unit. If he's unavailable, she's more than able and willing to provide any sort of transportation. And frankly, again, these children are going to be the 18-year-old frankly can drive himself and the 15-year-old will be 16 soon. So I don't think this is an issue, but my client should have the ability to free flow and have access to have his wife transfer the children. Similarly, mother is asking for prohibitive language that the 18-year-old child should not transport the younger sibling. Again, this child turns 18 on October 5th and falls outside of the jurisdiction of the parenting plan. My client explains that he obviously will comply with any Washington state standards and he's going to expose the younger child to any sort of dangerous driving. However, mother fails to acknowledge that she wants these restrictions, but didn't within our reply materials, we provide correspondence where she refused to allow the older child to engage in driver's education. So you have a situation where she refused to allow the driver's education, but then now is prohibiting the child from transporting because of said denial. So we think it's not appropriate to have any sort of restrictions. Both parents are good parents at the end of the day, and they're going to act reasonably during their residential time. I think that's the overall encompassing umbrella is we're trying to limit contact between the parties to avoid, the ongoing conflict. And we think that, again, parents should be able to, kind of dictate and control their residential time without the interference of the other parent. We believe that that is in the best interest of the children. So we do ask the court adopt our parenting plan as, again, we believe it's in the best interest. We did provide a subsequent order just clarifying the child support order. It is somewhat confusing, and I think both the final parenting plan and the final child support order have a litany of issues just based on the mediation agreement. But we do think the subsequent order is necessary. I did review the order prepared that was filed last week. We think that it's pretty consistent with what we proposed. What I saw the only difference is that just making it very clear that these parties are not going to be sharing these expenses that are between $3 and $50. I mean, it just can't be happening on a regular basis. My client is ordered to pay a basic support obligation of, I believe, $300 despite the 50-50 parenting plan. That really should encompass all of these costs. These parties, again, we're just hoping to avoid communication to avoid conflicts. Lastly, we ask the court deny a request for fees. Frankly, my client had a basis to request for fees in this case, just given what we believe to be bad faith in the communications we presented. He's not asking for fees. This obviously needed to go before the court because there's ongoing outstanding issues. We ask the court to deny fees for both parties. Thank you.
Quick question, Ms. Gilmore. The plan that I have from you is signed and dated 9/20/23. Does that include all the agreed things that you indicated that parents do agree on, or is there a newer order that includes all that?
That would include everything. That's the
This
most
one has
up-to-date.
everything.
Agreed. Yes.
Okay. Thank you very much. Ms. Dow, good afternoon.
Good afternoon. Christine Dow representing Jamie Lucas, formerly Jamie Bobbitt. Your Honor, as Ms. Gilmore pointed out, we've been working on this. We've come to agreement on several issues. I'll start with my client's request for attorney fees. This could have been settled in mediation. Mr. Bobbitt showed up for mediation last June and then walked away. That's really neither here nor there. We've been working on a form of that between attorneys right now. The amended proposed parenting plan that we filed yesterday and that I sent back to Your Honor to have looked at today and that I sent to Ms. Gilmore, that incorporates all of the changes that we discussed Ms. Gilmore and I discussed. I sent her an email last week. There's some areas on which we definitely agree. My client prefers mediation. Mr. Bobbitt doesn't, so we're fine with sending disputes back to the court. We don't have any problem with limiting parent communications to the Talking Parents app, and nothing else except for emergencies. We're fine with that. That's in the proposed plan that I submitted. We largely agree on the holiday schedule. However, my client does not agree to changing the Easter schedule to an overnight. That means that one parent will sometimes have at least 2 weekends in a row, depending on where Easter and spring break fall. We want to keep the holiday to Easter Sunday to limit conflicts with the regular schedule and with the spring break schedule. They've been doing that since they separated. We agree with the vacation language. We agree with most of the language in section 14 other, except that my client is making what we feel is a reasonable request that both parents should approve school trips that take a minor child out of the state. They haven't had problems agreeing to these things in the past, as far as we know. And it's an issue of taking a minor out of the state. Otherwise, parents can agree to whatever they're asked to provide permission for. We also, my client does not agree to the specific language in section 14 that limits communication with the children to the children's cell phones. Cell phones have always been a privilege, and both parents have agreed to limiting that privilege for short periods of time as a disciplinary measure with notice to the other parent. They haven't had a problem with that. We don't want to lose that flexibility, so we've proposed that it be by their cell phone, by email, by text, by Facebook, by whatever method happens to be available at the time. The main point, as Ms. Gilmore pointed out, that we are not agreeing on and that we can't seem to come to any accommodation on is changing the weekly exchange day from Sunday to Monday at school. They've been doing the Sunday exchanges since they divorced. My client is happy to make it at a later hour. The hour that she's proposed is the standard lights out hour at their home for their 17-year-old and their 14-year-old. If it should be earlier, that's fine too. The problem with doing the exchanges at school is that you have kids rushing to get ready for the week on Monday morning when they're also getting ready to go to school. They're hauling whatever belongings that they want for the week. They're taking those to school with them. They have to find a place to store them. Likely as not, my client is going to wind up bringing whatever they forgot or they absolutely can't live without on Tuesday. She's going to wind up being the one bringing them to the child because she's the only parent that doesn't have a job outside the home. We think that it's much more straightforward to just be ready on Sunday, drop the kids off at the other parent's home. And if the court agrees to not changing that that Sunday exchange, we would like the midweek exchange to remain on Wednesday. Your Honor, we've already addressed the issue and agreed on the issue of limiting communication between the parents. I think limiting it to the Talking Parents app and to dropping the kids at the other parent's door and driving away is going to solve that issue. My client's request to have a parent be the first choice to transport the kids to medical and dental appointments. That's not looking at a right of first refusal or controlling transportation or anything like that. It's just to maintain a flow of information for a parent with the child's care providers. You'll note in our proposal that if a parent is not available, have a step parent transport them. This is just something, again, that we're looking at simply as maintaining information flow. As to the provision that a teenager not transport their sibling, the language that we've proposed is not that they not transport their sibling, it's that they not do it unless they've had a driver's ed course. Now, we've worked this out. My client has agreed that both children will take driver's education. The order that we proposed, that we've basically agreed to, with a couple of changes for clarifying the support order, says right there that they'll share the costs for driver's ed. I don't think that's unreasonable, given that we're talking a 17-year-old and a 14-year-old here. And my client's concern in wanting to have this added to the plan is that under Washington law, once a child turns 18, they can get a license without taking driver's ed. It seems silly considering what it does to your insurance rates, but my client would just like to have that noted in the plan. I believe that covers all the areas where we have not been able to come to agreement. We're asking the court to adopt our proposed plan. I apologize when I submitted a clean copy for the court to look at. I submitted the one that I was sending to Ms. Gilmore as hopefully an agreed final order. So that would need to be changed to a temporary order if the court adopts that plan. As to the other order, clarifying the child support order, we agree with almost all of the provisions except that item B on Mr. Bobbitt's proposed order is unnecessary. It's not in the existing child support order that they should share all of these daily expenses. That was a voluntary arrangement they made. We've already agreed, understanding it, that's not going to continue. We're going to preserve the provisions in the original child support order. The only other thing that my client has a problem with in that particular proposed order, she has a problem with committing to language that requires her to share the costs for school-related mission trips, kind of on a blanket basis in the language of the order. Those can run into thousands, and she would prefer to be able to consider them on a case-by-case basis. She doesn't want to find herself in a situation where she's saying that she's not going to agree to allow a child to participate. It's just that she doesn't want to be automatically on the hook for something she might not be able to afford. So far, the parents have been able to work these things out, but we are asking that the court not require her to share that 50-50 if it turns out to be something extremely expensive. Other than that, Your Honor, I think we are basically very close.
Can you direct me, Ms. Dow, to in section 14, you indicated there was some proposed language about communication with the children that it should be.
She's looking at page 6, lines 15-ish to 17-ish. It just says that either parent shall be allowed to contact the children directly through their phones. It doesn't require it.
Oh, okay, that may have been a change that we didn't catch in all the back and forth that we did.
Okay.
My client is just concerned that they not lose the ability to use cell phone access as short-term disciplinary measures.
And I guess I don't see in here where it would limit email or like Facebook Messenger.
Okay,
or
as I
something
said,
like that.
we've traded a bunch back and forth. We don't have a problem with that.
I wanted to make sure that I wasn't missing something there, but I don't see language that would prohibit if someone's grounded from a cell phone that, there'd be other methods available.
Okay.
Any quick other remarks, Ms. Gilmore? Or?
Just really briefly, my client in his declaration details that the fact is the parties have mediated over 10 times. He spent over $2,000. I've never seen any parties mediate as much as these parties. He spent over $5,500 in attorney's fees trying to mediate this. We've set it over twice, and there's no agreements that we've been able to reach. I don't think these are appropriate in either case. Easter is one overnight under a proposal, so I don't understand the argument that would result in them having multiple weekends at once. Again, the Sunday exchange is problematic. We detail that in length. How, again, mother is prohibiting my client to come to the home without her husband present. But this issue with exchanging all of this property isn't alleviated by the fact that it happens on Sunday versus Monday, and the Monday just again allows parties not to have any communication. My client is asking for Thursday daytime visitation rather than Wednesdays. He explains that the children have been engaging in youth group, which is hindered by the Wednesday visit. And then again, we just ask that the court adopt our additional order. The parties haven't been able to reach an agreement on any of these issues, which has necessitated the reason for the clarification. So I understand that the order doesn't require it. However, mother's been pushing the issue for the last 7 years. So I defer to the court if you want to keep the language in section B of our clarification order. I would also note that the language is agreed mission trips. Therefore, if mother doesn't agree to the mediation or the mission trip, then she wouldn't be ordered to pay it.
Okay, and Your Honor, we're just asking for clarification on that. Again, as I said, my client does not want to find herself in a situation where she's not agreeing to allow the children to go, just that she needs to be able to agree to paying for it on a case-by-case basis. And as far as this business about not allowing Mr. Bobbitt to come to her home unless her husband is there, if the parents are not communicating except through the Talking Parents app and they're just dropping the kids off, problem's gone.
All right. I'm gonna work backwards here. I reviewed everything. I am gonna adopt father's proposed with some modifications. So order clarifying final child support under section 1A, I added agreed mission trips, including payment for agreed mission trips. So it's kind of a two-part. We agree that they can go and that we can pay. Under section B, I put within reason. This is a long-term parenting plan that's been happening. These kids shouldn't have to pack up all of their belongings every time they switch homes every week. I would imagine, each parent could have a toothbrush and toothpaste and toiletries there for each kid. And if they have, a Game Boy or headphones or whatever that they want to take back and forth, that's on them to take back and forth. It's not on the other parent who may have stuff left behind to bring that to the kid. I am going to do the exchanges Monday after school. That does seem appropriate. You can get ready for Monday school on Sunday evening, just as well as you can get rid of used to a Sunday evening exchange on Sunday. So I'm going to adopt the plan that way. I did change Easter on section 10, line 17, begins and ends on Easter at 9 a.m. until Monday the next day. And I believe when I read everything and went through everything else, that was the only change I had for the parenting plan, and I'm going to otherwise adopt that. And I also signed an order of adequate cause.
Your Honor, can I just clarify something, please? You said 1B within reason. I'm assuming that also refers to the order clarifying the child support order. Is that correct?
Yes, sorry, thank you.
Okay.
So if there's some major purchase that must be made while it's that parent's week, that doesn't mean that you have to bear that if it's something outside of the ordinary course of needs. So that's why I just included within reason. I would hope that would give enough guidance to the parties that they would know how to work that out. Right, and I will get those orders submitted to the clerk as soon as we're done this afternoon.
Noel
Thank
McLean
you.
appearing on behalf of
Thank
the
you.
petitioner,
Good
Colleen
luck.
Gilman.
And Christine Dow appearing on behalf of Tristan Gilman. And if you will just give me a moment to swap pages.
Sure. Just so all the
Okay.
parties are aware, Ms. Day is on a tight timeline, it sounds like. And I know this is on, the only thing on I have is a review hearing for a final GAL report. I know that there was some declarations that were filed as well. I don't know if those were specifically noted on to be addressed today, but I want to hear from Miss Day first because she may have to leave us here.
Thank you, Your Honor. I appreciate it. So this is not the final. We've had quite a few discussions going back and forth about completing this amended report, because this is an update to a complete report that was done previously to address father's mental health and compliance with the prior court orders. So I've not written my report based on those discussions. If the court would like that to be done, I can make that happen within about 2 weeks, but that would not include information that we have all been waiting for from the psychological evaluation. So that will kind of me today on how the court wants me to proceed. I have met with both the parties. I've been to both of homes in the past and fathers recently, and had an opportunity to do some investigation. It would not take long to get it done, but it would not include the psychological. So just wanted to provide that information up front.
I'm going to just turn to each attorney briefly on, I guess, some of these evaluations. We've been waiting for GAL reports, what feels like indefinitely, to get those. I don't know if you want to weigh in on whether we'd rather have all the information we can sooner without that evaluation, or if we want to consider waiting for the evaluation. So I'll start with Ms. McLean.
Well, I guess overall, my preference would be that we have the information, because I think that that's going to be vital for determining this court to determine what's appropriate for Freya in her relationship with her father. But in the meantime, I mean, this has been outstanding for 6 months with no positive movement forward by Mr. Gilman, which clearly he controls all of the strings as far as connecting with the VA for counseling, which he hasn't done for nearly a year now. Following through with the court order that's been out there for at least 6 months. And I mean, if you go back and look at the VA records that we provided to the court, it's replete with no-shows for his prior counseling. I'll remind the court that we had a circumstance where he basically quit his medication and then had a suicide incident that wasn't disclosed until after the fact, which again places this child in harm's way. We have an individual who continues to, he doesn't have a job. He's got a lot of instability in his life. He has no job. He has no appropriate housing for this child. He's basically living in a shed that has no plumbing or running water or a toilet or anything. It's not a tiny house. It's not an independent living quarter. And we still have the child reporting to her mom about having difficulties waking up dad when this court placed constrictions on him about not gaming when he has the child at night. And again, it's just the same argument. It's like a rehash on a record that's been playing for months now. And when we're talking about an individual who's already been diagnosed with PTSD and major depressive disorder, and his action is to stop medication against the provider's recommendations, not engage in counseling, even though this has been brought to the court's attention, and to suggest that, well, my non-compliance is all Colleen's fault because she won't accept this. That's unacceptable. And again, it places this child at risk because he remains at risk when he is not appropriately addressing his PTSD and his significant mental health issues. We're getting into the holiday season. Everybody knows that holidays tend to be a huge trigger for mental health, especially depressive issues. So I'm just concerned by the fact that previously we filed a motion with the court asking to terminate and or reduce his time. The court gave him strict marching orders, and we are in the same position as we were earlier this year. So if anything, we would ask that the court consider terminating visitation until he can provide verification and proof that he is moving towards stability, that he's at a therapeutic level for recommended prescribed medications, and that he is consistent in counseling.
Ms. Dow, thank you.
Your Honor, some of this is a rehash. My client is not saying that anything is Colleen Gilman's fault, nor is it true to say that there's been no positive movement since we started this. My client set up for a mental health evaluation. We discovered past the time that he had done it and paid the fees for it, that was not going to be from an acceptable provider. And I'm not putting that on anybody saying that's acceptable or not. I think we all agreed that that is a provider that is not going to provide what we're looking for. So we are now on the waiting list with Ms. Day and Ms. McLean's preferred provider, Dr. Stephen Mayhart. I checked with his office today. We're still about 6 weeks out. My client outlined all of this in his declaration. He went for a counseling appointment with CORE, but that was right around the same time that we were being told that CORE was unacceptable. He has reached out to the VA to start counseling with them again until he sees Dr. Meharg, and Dr. Meharg gives him a program that he wants him to follow. As far as the medication issue is concerned, my client says this in his declaration. He did go off his medications. He went off because they were making him feel worse. He did not just drop it and hope for the best. He followed doctor's recommendations for non-medication alternatives, and they seem to be working. Nobody is claiming that he is not going to have a problem in the future, but it is not a given that medication is the only route to mental health. He's been following his doctor's suggestions for meditation, for exercise, for reaching out to his Warrior Path group. If he feels like he's having an issue, he reaches out and talks to them. The alternative drug-free program is working better for him than the medicated program was. He gave very specific facts about what happened on the last weekend the child was with him, about waking him up. Ms. Gilman's declaration just says that the child told her that she couldn't wake him up. Well, my client described exactly what happened. And she did wake him up. He tended to her through the night, did what any parent was supposed to do. Finally, this business about saying that my client lacks stability because he doesn't have a regular job, or that he lives with his sister and he has a building that is immediately adjacent to the house that gives him space so that he is not crowding his sister and her family, and they're not crowding him. He pays his child support through his disability benefits. As he said in his declaration, and as has been known and discussed, he is starting a business. It's one that he has experience in. He is probably 99% through all of the certifications and licensing he needs to start up in the spring. The fact that he is not going to work at the mill and living in a small house where he pays rent to the tune of $1,000+ a month doesn't mean that he's not stable. And once again, this question about terminating my client's time with his child, that's not before the court today. And I don't think that the guardian ad litem has said that in her recent contacts with them that she sees where the child is having a problem now. Everybody is rightfully concerned about potential future problems, but right now things are going fine. And we are in the queue for addressing the mental health issues.
And you said Dr. Maharg is 6 weeks out still, or 8?
Well, I talked to his office today, and between I don't know and between he makes his appointments by himself and yada, 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 we agreed that it was probably looking like about 6 weeks, which is why my client has reached out to the VA to start counseling sessions with them again, at least as an interim measure until Dr. Maharg comes up with an evaluation and recommendations for him.
Other alternatives could be Dr. Jeff Lee or Dr. Poppleton. And I don't know if either of those individuals have been contacted.
I have contacted them for other cases, and they are not only further out, they are also considerably more expensive, especially Dr. Poppleton. My client is paying for this out of his pocket. He does not have health insurance that's going to cover this. And again, I'll remind the court that he is receiving an 80% disability benefit from the VA and starting a business.
Ms. Day, you indicated that you've recently had contact with the parties in this case. Did I hear that correctly?
Yes, that's accurate. I've done a drop-in visit at Father's home. So here would be my input on this kind of circumstance. I don't have issues with how Father is living. His home is clean and appropriate. It is outside within maybe 15 feet of being able to access a bathroom and a kitchen sink and running water. So I don't think there's any major concern with that piece of it. My main concern is that the child is still reporting that she's having difficulty waking Father up, and that not only is the psych eval not completed, but he's not in counseling. And I've been asked to do this update for the past 6 months. So I think those two things give me the greatest concern. Freya loves her dad and they do have a bonded relationship, but there's nobody there to make sure he is going lights out and not gaming at 9 o'clock at night after she goes to bed. And then the issue, which has been all along in this case, is his inability to respond to this child when she has needs in the middle of the night or in the morning, because he is up all night and doesn't get up with her in the morning. And so that really is the issue and the concern. The not being in counseling is a concern because it's only been 8 or 9 months now since the alleged suicide situation was brought forth. And since then, Father has done the Warrior Path, which I think was a great program for him, but that does not provide for that ongoing stability or for anybody outside of Father to say, I'm doing great. We just don't have another professional saying that he's meeting with them weekly or biweekly and checking in with them, that being off medication and out of counseling really just comes across as non-compliant. And we have a very young, very emotionally fragile, sensitive child who's in this home every 2 weeks with no way of knowing what exactly is going on.
The only thing that I would couple on top of that is Ms. Dow argued that, he has come off of medication and is doing alternative therapies. When I reviewed through the VA records, there was nothing in there that had alternative therapies that they had recommended. And he had reported to his provider that he had quit his medication because it didn't make him feel good. And it wasn't that he didn't feel good. It was that it interfered with his sexual activity or sexual performance. So he quit his medications cold turkey, which is contraintuitive to the prescribed medications that he was on. Typically, you would titrate down with approval from your medical provider. He didn't do that. And again, he's not in counseling at all. He has not been in counseling. I'm not aware, and I have not received that I can recall that he had done a counseling session with CORE. I don't recall seeing any of that. And the Dr. or Ms. Ledvigsen, who had performed the initial assessment with CORE, had indicated, if I recall correctly, and Ms. Dow will correct me if I'm wrong, but my recollection was that she indicated that she was unwilling to take collateral input from either the GAL or from my client, which was ordered in the court order. So those are all concerns that he, as Ms. Day indicated, there's no independent third party that's able to provide a report as to how they believe that he is doing, having so recently had this suicidal issue.
Well, Your Honor, we can provide evidence or reports from the VA once he gets started with them while we're waiting. And if he doesn't do it, then, clearly he's not doing what he's supposed to do. But at this juncture, I think that taking away his daughter's time with her dad is when nobody is pointing out that there is a problem at the moment. I think that's probably pushing things a little bit too far. Again, as I said, we all agree that mental health issues are important and they are of a concern. My client is doing his best to comply. We can reach out to CORE for whatever records they have of the one counseling session that he went into. It was the fact that the CORE evaluator wouldn't accept collateral input. She didn't want to share information with anybody else. That's what alerted us to the fact that CORE was not appropriate for this. My client has moved on from that.
Okay. I understand the concerns, and he's not currently employed, correct? He's just working on the business, getting that set up.
Right. He's getting that set up. He can offer to the court proof that what certifications he's completed, where he stands on his business license and so forth, if the court considers that a real issue.
No, I just wanted, I guess, I appreciate that he's getting that up and running. I also appreciate the concerns that it does seem that we've been stagnant for a period of time. He needs to understand that he can't willy-nilly make decisions about his mental health medications without there potentially being some fallout from those decisions. I would agree with Ms. McLean. Some of the medications that it appears he was on, just not taking those anymore could be extremely detrimental to him, let alone to people around him if things, go wrong. I am concerned that I appreciate that he's starting up a business, but if he's not employed and he's just getting certifications, this is something he can spend a lot of time on. And I just don't see that happening. I do think if we're only 6 weeks out at this point from a hopeful appointment with Dr. Maharg, we wait for that. But what I would like to do is I'd like to set this for review, and Ms. Day, I don't expect you to, if I'm looking 6 weeks out, I'm looking at actually November 14th is when I want to review this. That would be, hopefully the evaluation would have happened by then, not that we'd have necessarily a report, or Ms. Day's report would be done. But I do understand the concerns that Ms. McLean and her client are raising. We are getting into the depressive time of year with the holidays, with the weather, with everything. And I think Mr. Gilman needs to make a more valiant effort to address these concerns rather than be a passive participant in his own mental health, because that's frankly what it looks like at this point. So I want him to engage with whatever services he can. If there's Wounded Warrior services, I know he indicated in his declaration that there was a counselor that he didn't get along with. I can't imagine there's only one available. And I know that there are other veteran services that are available.
I
That
think that reference was with regard to the VA, not Wounded Warrior.
was it the,
I don't,
okay.
I
Yes,
don't
Your
think
Honor,
Wounded
and-
Warrior has ongoing counseling.
Sorry,
VA
I thought and I misspoke. So the VA counselors who he had issues with, and I can't imagine that there's only one of those available. I understand that our veterans are underserved. I understand that, but I would hope that there are other options available to him. He needs to seek those out. If there's any Wounded Warrior meetings, anything that's free that he can attend, I want him to start doing that and make a log of those meetings. And he should be attending at least 3 things a week. Whether that's a session with a counselor from the VA, whether that's a Wounded Warrior mentor type individual that he has meetings with. And that needs to happen 3 times a week, or whether he gets an actual counselor through a service provider here locally, that he's doing those things, that we get this Dr. Maharg evaluation completed. We're going to review it on November 14th. Ms. Dow, I want you to submit to the court and Ms. McLean the logs of what he's doing. And frankly, that's going to give us a little bit better picture of, is he putting the work in to get this addressed? And I understand not having insurance is a hurdle, but I would hope that there's some additional options out there if he looks into it through, if not the VA or the Wounded Warrior projects, through some. I know there's a lot of different programs available to veterans that maybe he can find one to utilize and get connected with. Frankly, I mean, even if he volunteers at the VFW on a regular basis and meets other individuals in that respect, some way that he's making contact and making positive things, and he's not just holed up working on this new business and playing video games when he doesn't have his child. Then we'll review it on November 14th. If Ms. Day has any updates to provide us at that time orally, that's great. I don't expect her report at that point, but I do want to review this sooner rather than later to ensure that those things are happening. At this point, I'm not inclined to stop visitations. However, I think Mr. Gilman does need to understand that, I mean, this is the shot across the bow as far as he needs to make sure that he's addressing these things and addressing them appropriately, not just willy-nilly how he wants to, in order to ensure that he keeps visitation going on a regular basis with his child.
Is the court inclined to at least reduce visitation so that we don't have the child there overnight pending the review, given that that continues to be a problem for her?
No.
All right. Presentation.
I don't believe I'm here next Tuesday. So, and I don't, I have Mariah, I think, as my clerk today. If, I don't know that anything's closed upcoming.
I haven't seen
So
anything closed yet. So the 10th.
the 10th would work if that works for Ms. Dow.
Yes, that works for me, Your Honor.
Prior to
Okay.
hearing
The
argument
10th at
on
1
this, I would
p.m.
like
Thank you.
to request a continuance of these motions. So my motion for to change child support, as indicated, I've done interrogatories to counsel. They are due. My staff contacted counsel, and she indicated we couldn't have a CR 26I until October 25th. So I don't have his tax returns and other financial information. So all you have is the declarations. So my thought is we would continue this to trial, which is set for the week of November 6th. So just a month away at this point. And it would be part of trial that we would at that time hopefully have all of his financial information and be able to appropriately address child support. And in the interim, leave it at the 427, which is what he's currently paying. Then with regards to the visitation issue, so I note on Ms. Corey's report, this is on page 37, that Mr. Hoffman affirmed that he was selling the house, but that he would basically, it states that he was going to stay in Arizona. And the issue is Cash is flying or had been going to Arizona periodically from time to time. It definitely wasn't 30 times a year. And now that he's moved to Washington, D.C., he's enforcing this, and it's a lot longer flight. And we think it's it's 16-hour flights for a weekend.
Excuse me, Your Honor, are we arguing the motion or?
No, I'm arguing a motion for continuance.
Okay.
So the request is, this is my request with regards to the visitation. Ms. Corey has finished her report that we set this out 2 weeks for her to weigh in on if this is a good idea for Cash to be traveling 16 hours on a weekend to visit. I mean, this wasn't contemplated at any time in the orders or in Ms. Corey's report. And I'm saying 2 weeks because I don't know if Mr. Hoffman has any scheduled visitation. If he doesn't have any visitation until trial, we could set this out for trial and get some kind of information on how this is going to work with Cash having to go to Washington, D.C. on a weekend, around his school schedule and everything else.
Thank you, Ms. Cotto.
Thank you, Your Honor. So I don't object to the issue of the child support going over to trial, because I understand that we don't have a CR 26I until October. The problem is I leave them for vacation. Like I'm supposed to leave Friday afternoon. I'm leaving a few weeks and I'm just not available. I'm not trying to be difficult, but this has been a pre-planned vacation. The issue in regards to the visitation, it is a problem because we did serve all the parties, including Ms. Corey. My client had a visitation that he was requesting for September, which was denied. We then he gave notice for visitation for October and November. And my client, upon my recommendation, gave a full list because who knows if we're going to get out in November. That's been the biggest problem for the family law cases. And he wanted to make sure that he was timely in doing this. It isn't just weekend visitation. What my client was requesting is that it is the long weekend or holiday time. The one in October is October 19th through the 22nd. Those are days off. He's not asking to remove the child from school. We would dispute the allegations contained as to what Mr. Anagnosto is stating. And the problem is putting it over 2 weeks is going to be a huge problem for me, just because I'm going to be gone and I'm going to be about 10 hours ahead, and don't know if I'm just not sure what the Wi-Fi would be like in 2 weeks. I would ask the court to at least go forward on my motion for travel because this is something that the parties have been historically doing for several years. I think that the court can make a decision, at least in regards to the October visit, but we'd like to be heard.
And that's October 19th through 22nd. That's current.
Yes, that was the visitation. And then there was one, it would look like the November 17th to 26th in the event we don't get out. And I have another trial, dependency trial scheduled for that same week. So I don't know if we're going to get out at that time.
Okay. So we have an agreement to set child support over to time of trial. Obviously, if the current set trial is unduly delayed, then that can be raised again. But at this point, we'll pass it to trial. As to the concern about the unaccompanied flying and dad's move from Arizona to the DC, Virginia area, I guess given Ms. Cotto's out of office time, upcoming out of office time. I think in September, he's supposed to have one visit a month. Is that correct?
That's correct. And he's scheduled it where it's always a long weekend. He doesn't just take the child on a Friday. It's Friday after school. I'm looking at the schedule. It's till Mondays. He's scheduled it on all the 3-day weekends he could find. And I just want to make one point to the court is when we originally did the dissolution back in 2018, my client was living in Virginia or I'm sorry, North Carolina. So there was the long distance travel, things have changed. And that's why all of a sudden we're concerned, because Ms. Hoffman is saying there's going to be no visit if my client doesn't come pick up the child. So if the court is going to continue this matter, I would ask that the unaccompanied minor happen at least for the October visit. And then if in fact we don't get out in November, that we can come back before the court and address the remaining time period, but we need to do it before my client's scheduled visits, because he's given timely notice.
And I'm sorry, remind me, the September visit, was that just mom said no? Or
Yeah,
was
she said, what she said was, well, the order says you have to come pick up the child. So unless you come pick up the child, you can't have the child. And that's not what the parties have been doing. And that's the bone of contention.
Okay.
That's not correct, Your Honor. The order provides that he is supposed to buy a round trip ticket at some period of time before, it's like a week before the visit occurs. And she never received a round trip ticket. She just received a notice that he wanted cash in September, and it was like a last minute thing. I mean, she had virtually no notice. And so it violated several provisions of the parenting plan.
We dispute that.
So if there's a round trip ticket purchased for cash for October 19th through 22nd as an unaccompanied minor, she's going to allow him to go on that trip.
That's what the current order says. So yes, she's not going to violate a court order.
Okay, here's the problem. She's now saying the current order, and there's two conflicting orders. One of the child support order says you got to share unaccompanied minor fees. The other piece of the order, which is in the parenting plan, it says my client will come pick up the child. At the time of that order, the child was 4 and the older child was, I believe, 12 or 13. So then what happened was these parties, one child is aged out, she's gone. And what happened is, and if counsel is saying, well, she'll abide by the order, what happened is she said, no, wait a second, we're going to revert back to the original order and say, you don't get to have the child unless you come pick him up in Idaho. So if the court's going to order this, I would like specific language. It says the child can fly unaccompanied minors. He purchases the tickets. We can provide that information. He can go unaccompanied minor. There's huge, strict rules. And then we can come back before the court in regards to this issue. Because if the court orders, you follow the current order, she's going to deny the visit. She's going to say, well, you have to come to Idaho.
Okay. The child, I will order that the child clearly has been flying as an unaccompanied minor, can continue to do so regardless of where father resides. And I say that just because it sounds as though this may be an ongoing issue, and hopefully we'll have trial soon and it will be addressed there. Tickets should be purchased and notice given as timely as possible, but no later than a week prior. Sounds like the 19th through the 22nd is already the date selected, and mom should be on notice for that. So any information to her as soon as possible. And then I will continue that order. If for some reason we don't go in November, notice given, child can fly unaccompanied over the dates that are selected and agreed upon and planned out in advance.
Your Honor, I note that counsel has indicated October 19th. That's a Thursday. I'm not aware of any holiday around October 19th. I'm not.
My understanding that I believe it's an in-service day. My client specifically scheduled it so that those are days off. That's the information I have.
Your Honor, this is Corey Hoffman. May I address the courts?
Ms. Cotto, do you have a problem with that?
No, go ahead, Corey, because he's better familiar with the.
Your Honor, so I'm looking at the schedule right now, and the 19th and 20th is no school. This is for that county, Elmore County, for his East Elementary School that he attends.
And that's why these were specifically scheduled like that.
Okay. Well, I'll trust that that's accurate information and order that the child can fly unaccompanied, and the notice should be, it sounds like there was an agreement that it was at least a week prior, tickets taken care of. So that should continue to occur. Mom should not deny that. And I'm assuming that September denial will likely be addressed at trial. But moving forward, visits shall occur monthly as previously ordered.
Your Honor, my client has a comment.
The 19th is actually early dismissal. It is a school day. It is parent-teacher conference. Children don't get out until after 1:30.
I mean,
I'm not concerned about that. I mean,
Okay.
Assuming there's no major issues with his schooling or what's going on there. And maybe it's something that can be attended virtually by the parties when he's with dad in Virginia or DC, wherever he's going.
Okay. I will present and I will send an order to council and present an order. And if we have an issue, we can note it on for presentation.
Your Honor, this issue is going to, be a big part of the trial. Because this impacts cash going 16 hours flying for a weekend. I'm just wondering if Miss Corey has already issued her guardian ad litem report, but as indicated, it didn't have this issue in there. How do we need to reappoint her to ask her to? I mean, I'd like somebody to weigh in with the best interest of cash besides my client and Miss Kudo's client.
Your Honor, this child's old enough to, we have kids traveling all the time cross country. So, Miss Corey made her report in regards to custody, which is going to be an issue. I don't think that there's any point in rehiring Miss Corey to say, well, should he fly to Virginia? My client is retired military. He may be moving again. We don't know. At this point, he's where he's at for several years due to his fiance's schedule. So my suggestion to the court is we just move forward and we can make our pitch to the court.
Ms. Corey, since you're here, do you have any, you want to weigh in at all, or do you have a position? Noting that, I guess, when this unaccompanied minor flight started, that we were talking about Washington and North Carolina, I believe, and now we're Idaho, Washington, DC.
Well, if I read the pleadings correctly, that Cash has actually only flown to Washington, DC by himself once. He's 9, I believe now. It's been a long case. And those flights are anywhere from 6+ hours to 22 hours with 2 layovers. I guess that gives me a little bit of pause for a 9-year-old, whereas the direct flights they were doing to Phoenix were less troublesome.
And Your Honor, I think in response to that, I don't think it's that long of a flight. It's not 22 hours. I fly back east pretty regularly because I have an elderly parent. So I've flown in and out of Durham, North Carolina several times already this year. It's never been 22 hours. It's been at the most with my layovers, maybe 7 hours, 8 hours. And these are well planned. They're short turnarounds. And I would be objecting to, counsel didn't give me any notice that he was going to be requesting to have Ms. Corey weigh in at this point. So I'd be objecting, at least getting something in writing if that's the request.
Well, Ms. Corey serves at the discretion of the court if the court wants additional information.
I think I'm not inclined necessarily to reappoint Ms. Corey at this point in time. I think judicial notice can be taken of the age of the child and the length of travel and the information that's already been submitted. So unless the parties at some point agree to reappoint Ms. Corey for an additional handful of hours to address this issue, I'm not inclined to do it at this point. So right now, hold on here. Do you want to set a presentation, Ms. Cotto?
Yeah, we can, but I'd have to set it for the 24th. Yeah, the 24th of October. I'll get a proposed order to Mr. Anagnosto. And if it starts to become a problem, I'll have somebody cover it for me while I'm gone.
All right, we'll set a presentation for October 24th at 1 p.m. If that's an agreed order, we can strike it. And then it appears that readiness is set for October 31st at 11:30.
Okay.
All right, good luck.
Yes, Your Honor.
All right. So we're here on a review. Do we have any updates?
And Your Honor, Mr. Zandy did file a declaration on behalf of our client Cheryl Rapp on September 8th, is the conform stamp that I have. I don't have any subsequent information. So my understanding is the sentiments contained within that declaration still remain.
All right, Mr. Rapp, have you made any payments since the 8th of September?
Yes, I made a $700 payment.
How much of a payment did you make? I'm sorry.
700.
700. And when did you make that, sir?
Yesterday.
And did you, are you paying through the registry, or did you pay directly to Miss Rapp? How are you making those?
I take and give it the money to the secretary at the lawyer's office.
So you dropped $700 off for Miss Rapp at Mr. Zandy's office yesterday.
Yes, I got the receipt right here.
Miss Bliss?
That is news to me. I did speak with Mr. Zandy's legal assistant just before this hearing to confirm. I can go downstairs and check our books to also confirm. I do know that historically he has paid when he has paid through our office. So if he claims that he did, it should be easily traceable. But nevertheless, it's a $700 payment, and my understanding is he's in arrears of upwards of nearly $16,000. So I would argue that that's insufficient still.
Well, what it is, he claims I make over $5,000 a month, and I don't. I've got all my receipts from when I worked for J.H. Kelly, and I've only worked 7 times for J.H. Kelly since March. And I think I've grossed $3,000. I've paid her over $5,600 so far.
All right. Well, we're just on continue to reviews, Mr. Rapp, to ensure payments are being made. I'm going to take your word for it that there was a $700 payment made. If you have that, I do want to let you know that my understanding is that you recently failed to appear for a mandatory settlement conference, and there may have been another judgment imposed against you for your failure to appear there. So you're not helping yourself in some ways. Miss Bliss, do you want to set this on for another review in a few weeks?
I have a court appointment tomorrow, mandatory settlement tomorrow.
Is that right?
And Your Honor, I believe that's for trial assignment, but nevertheless, I would ask that this be put back on if we want to set it, a couple weeks out. I can confirm that $700 payment was made yesterday, and we can confirm that he is or is not continuing to comply with the order and paying his ordered spousal support. Mr. Zandy did want me to make the request that Your Honor consider jail time. Obviously, with the hubbub of today, I understand Your Honor may want to reserve on that, but I would just like that on the record as well.
All right. So Mr. Rapp, you are correct. So I may be wrong in my prior comment. You do have an assignment for trial setting of an MSC tomorrow at 1 p.m. So that's a Zoom hearing tomorrow at 1 p.m. So you are correct that there. Yeah. I'm going to take your word that you made that $700 payment. I will tell you that Mr. Zandy is still requesting that I put you in jail. I'm not going to do that yet, as long as you keep trying to make efforts. Do you want to review this?
I'm doing the best I can do, man.
I understand that, but there's a court order in place that requires you pay certain things, and there's other fines and fees that have been assessed against you. So many of those that have nothing to do with me that were just imposed. So
what happens on the mandatory thing?
Mandatory settlement conference is an opportunity for you to resolve the case short of trial and do basically negotiations with a judicial officer and the other party. So that's what's on for tomorrow to be scheduled. So
because I tried getting a loan, but I can't do that until I know what's going on, because if she gets into my retirement, I won't have enough percentage to get a loan.
And those are those are the perfect type of things to bring up during a mandatory settlement conference to try to see if you can negotiate a resolution that works for everybody. So I'm gonna, Ms. Bliss, again, did you say a few weeks or a month? I'm sorry, what?
That's okay. I would request maybe October 10 if we can. I know Mr. Zandy's scheduled to be out the week of the 17th. And I don't want to put it too far into the month just in case for whatever reason that 700, obviously assuming that that $700 payment has been made, but worst case scenario, it hasn't. I would like to review that sooner rather than later.
Okay, so I'm going to set a review. Hold on, Mr. Rapp. I'm going to set a review for October 10th, 2023 at 1:00 PM. Ms. Bliss, is that something that you're willing to have struck if that payment was made, and then we can just carry on to the mandatory settlement conference?
Yes, I will.
Okay, so Mr. Rapp, assuming that the confirmation of that payment is made and that you're still making efforts to try to make payments, then that court date can be struck, and you just need to make sure you're at your the scheduling for the MSC tomorrow. So you'll hear from someone from Mr. Zandy's office regarding the 10th, but at this point we'll set it as a review.
Okay, how much am I going to have to give to stay on the jail? I can't afford going to jail.
Well, and I don't know that I don't particularly want to send you to jail, but I do know that in the most recent information I have, you are about $15,000, almost $16,000 that you owe the petitioner in this case.
Is that even with the $5,000 I've paid?
That is including the money that you've paid, so that's what you still owe.
Jeez. Okay.
Your Honor, the only remaining request I had from Mr. Zandy today was there was a scheduled mandatory settlement conference on September 7th. Mr. Rapp failed to appear at that settlement conference. Commissioner Warning had assessed $500 towards attorney's fees for his failure to appear. Mr. Zandy did ask that that be reduced to a judgment. If Your Honor is willing to do that, I would just ask that I be permitted to present that for presentation on October 10th.
Yes.
Your Honor?
Yes, sir.
I was on the computer trying to get into Zoom that day. And I even called the clerk's office, everything, give me a bunch of numbers. So, and they told me, well, now it's over with. So I asked them what I could do. So they told me to come down here, and I filled out papers and just reschedule it. I took a picture on my computer, my phone, all the phone calls I made. I was trying to get in, but I couldn't get in for some reason.
All right. Well, if you, okay, I'll reserve on that then, Ms. Bliss. So I take that back. But Mr. Rapp, you have to provide the proof that you attempted to get in and whatever information that you can show that you were attempting to get into that hearing. And if you provide that to the court and it's sufficient, then I'm willing to waive that fine.
All right. Do I fax pictures of my computer and all that, or what?
You would file it just like you would file anything else in the court document. And if it's something that doesn't have the proper margins, you just would do a cover sheet, and you can file that with the clerk's office and make sure that you provide copies of whatever you file to Mr. Zandy's office as well.
Okay. Yeah. I was trying to get in. My daughter was right here trying to help me, and it kept telling me I couldn't get in. I don't know what it was.
I'm not going to say that doesn't happen. So just file whatever you can in relation to that, and then we'll reconsider the $500 fine that was imposed.
Did I file at the Superior Court then?
Yes, sir.
All right. Thank you.
All right. Good luck. Thank you. Thank you. I'm Mr. Fisher, Michael Fisher. Don't have anyone in the waiting room either. This is a review for final GAL report. I don't have a GAL report. You didn't file one, did you, Ms. Height, that I missed?
No, Your Honor, I did not. I'm still waiting for documents. I'm sorry to say.
Nope, that's okay. Ms. McLean.
So at this point, what I can tell the court is that it appears that Mr. Fisher isn't complying with anything, to be quite honest. We were last before you on June 27th when the court heard Ms. Height's recommendations on a temporary or an interim guardian ad litem report, and that order was entered, I think, maybe August 1st. At that point, you ordered Mr. Fisher to participate in a deep domestic violence evaluation. I did ask my client to reach out to Ms. Lovely to see if by chance she had been contacted. Ms. Lovely did tell my client that he has an appointment scheduled after today's hearing date, but she wouldn't provide a specific date. She did take my client's contact information for collateral input, and I think that my client is providing some input to her once that is complied with, but there's no guarantee that he's going to follow through with that. He has not complied with the drug testing. I did file under sealed health the receipts that he had dropped off here at my office. I contacted Ms. Esty, Laura Esty, who is the go back and look at my emails, but to see if they had results and whether or not there had been a release signed for me. And I provided a copy of the order, and she reached back out to both Ms. Height and I today, indicating that she had been trying to reach Mr. Fisher by phone, that he will not return her calls, and that the sample that was collected on whatever date that was, on September 16th, was an insufficient sample, and he needed to resubmit a sample. Of course, my concern is we're 3 months removed from when you ordered that. And to me, that smacks of masking, because he certainly avoided a significant period of time that would be covered by a hair follicle test. He also has not complied with discovery. He was ordered by this court one last time. You've bent over backwards for him to comply with discovery. He was to produce the balance of discovery to my office this past Friday by 12 noon. I filed an affidavit outlining the fact that I have received nothing from him as far as the missing discovery, much of which relates directly to the concerns and allegations around his mental health, substance abuse issues, financial issues, and quite frankly, parenting plan, because a number of those questions that I asked dealt with parenting plan issues, his beliefs, his practices, his involvement, and to try and ferret out what the true issues are from his perspective. So he still has not complied with any of that. He has not provided the documentation that you specifically ordered from the Veterans Administration, nor from Wayne Anglin. Again, he claims that he had provided me with signed releases. I have not received releases that would tell me who I'm even supposed to be contacting for records. And the court's tasked him with doing that. My client shouldn't have to pay additional attorney's fees trying to subpoena records that would comply with HIPAA and the like. This is his obligation to basically put up or shut up for purposes of his position at the time of trial or moving forward. My affidavit also outlines that clearly he's not operating in good faith. You previously have entered a finding of contempt against him where you made a specific finding that he was acting in bad faith. As you know, originally there was a protection order entered protecting my client and the children. There remains a restraining order in this case, again, protecting my client and the children. And when you did enter that finding of contempt earlier this year, that was one of the bases were for not only him violating the restraining order, but also for him continuing to remove monies from the account, which you had indicated were monies that were to be restricted solely for use for my client for the community bills and for the children. Despite those orders and despite my repeated correspondence to Mr. Fisher, he continues to remove and has even added new accounts as automatic withdrawals from this account. So right now, through August 31, he's removed an additional $667.60. He has continued to remove monies this month, even after, again, we've filed and provided him this declaration. He currently owes my client $553.50 in uninsured healthcare expenses for the children that we provided the billing to him. He's not paid the $500 per month towards the contempt judgments that you previously entered, and not including accrued interest on judgments that have been entered right now, as we sit here, not including the month of September, whatever he's withdrawn for September. He currently owes my client $4,184.57. That's for the monies that he's removed, the unauthorized monies that he's removed, for the uninsured healthcare expenses, and for attorney's fees. It is clear that he is just not making any good faith effort here. My client, as a single parent, is raising these children on her own. If you recall, she homeschools these children. And so the monies that are received by him are her sole source of income. She's also under the court order in the process of trying to get this house ready for sale. And we need him to cooperate in picking up his personal property items from 3 different locations at the house so that we can get it listed. And so ultimately, we are, quite frankly, asking that the court enter a default due to his non-compliance with discovery that was previously entered or requested of the court. We entered an original compel order back on August 8th of 2023. And you've provided that if the court determines completeness or sufficiency has not been met, then the court may strike and not consider all of Michael Fisher's pleadings and enter an order of default. We are asking you to do that. My client is asking to be able to move forward and finalize this matter. He certainly is not here in good faith. So we're asking that the court enter a default. I can submit an order ex parte upon the court's approval. I think, again, his no-show, I think, speaks to the position where he currently is in this case.
I appreciate that. Thank you. Ms. Hyde, my recollection was the initial report, you had cooperation and communication with Mr. Fisher. Has that dropped off, or I guess, what is your perspective at this point?
You are correct, Your Honor. Both parties have been cooperative. I have had very little contact with either party later. I have spoken with Mom on the phone and visited. It was in the late summer, I believe it was, and I've spoken with her recently. I have made multiple. I also did visit Dad about the same time last summer. I have had several tries to get in touch with him by phone, by text, and I have contacted a party that is close to him and tried to get messages to him through that party, who has been somewhat cooperative. I would say quite cooperative, actually, but it hasn't turned out to give me any more information. I've passed information, and there's been cooperation that person will let Mr. Fisher know, but I haven't received anything back the other way. So I'm disappointed that it has kind of fallen off of my radar in my ability to complete an investigation and a report.
So I would agree with, I thank you, Ms. Height. I would agree with Ms. McLean. I think I was maybe even overly sympathetic to Mr. Fisher at the outset of this case, and gave him a lot of benefits and consideration as we've kind of moved through this process. At this point, he was at the last hearing. He knew what the requirements are, and now it seems like a process that he started out being engaged in, he's just basically thumbed his nose at, not returning calls from the GAL, not responding to any discovery requests or following through with things, or I guess partial discovery requests. I know that Ms. McLean indicated specifically that, answers attached, and there'd be no attachments to things. So kind of the guise of responding with no real substance to the response. And frankly, a lot of the information that's still outstanding is basic work schedules, real property information, medical insurance information, bank statements, wage stubs, social security information. And then there's some of the information that may be a little bit more involved, because I believe this is another individual who, and I could be incorrect, but I feel like he's a veteran as well. So the medical and counseling stuff may be a little bit more involved to get access to, but he's not done any of that. And then when I hear that the UA that was ordered 3 months ago, they've been trying to get a hold of him to do it again because it wasn't sufficient, and he's just, I'm kind of at a loss here. I don't like the idea of moving straight to default in this type of case, but at this point, I am going to grant the request for a default. I don't think just limiting his responses or prohibiting discovery in certain areas is sufficient. I think there's going to unfortunately just be more concerns and issues, and this process will unnecessarily be drawn out.
Yeah. Okay.
If I might.
Yes.
Have a comment. When I visited the boys at Mother's Home, they were doing well. I would like the court to know that. And she's engaged in home teaching them still. I am disappointed that it's come to this, but I would like the court to know that the last time I saw the boys, they were having a good time and were doing well.
I very much appreciate hearing that, Ms. Height. Thank you for sharing that.
So on that default, then I guess, am I including that Ms. Height is discharged? I'm sorry, yeah, that Ms. Height is discharged so she can submit her final billing, because I think, isn't this county pay?
I feel
I
like,
have to look back.
Let me look real quick. Oh, no, it was private pay. So I'm assuming that you've already received fees. Have, Ms. Height, can you tell us if you've received payment from both parties?
If you could hold on for just 1 second, I keep that in a separate spot. Just one moment, please.
Okay.
I have received payment in full from Ms. Fisher and a partial payment from Mr. Fisher. About 1/4 of the fee that was owed.
So how much did you receive?
His portion of the fee due was $11.25, and I received $2.25 on March 15th. I'm sorry. Yes, that's correct. Yes, on March 15th, I received $2.25.
So he owes you $900.
Correct.
So is the court opposed to me including in the default order a judgment summary for Ms. Height for that $900 and then a discharge order?
no, that's fine. I would approve that.
Oh, okay. Okay. I'm sorry. I thought you were saying no, I can't.
No,
do
that,
that.
I meant, no, I think that's appropriate. I was going to suggest a default unless there was other suggestions.
Okay. All right. So I'll circulate at least that order to Ms. Height before we submit it to your honor ex parte.
All right. Thank
Okay.
you. All
Thank
right.
you. Which
Good luck,
files
Ms. Fisher.
there? Yes, may it please court, I represent the petitioner, Rebecca Rodriguez.
Right. And we have Emmanuel Rodriguez Stisser.
Yes, Your Honor. Yes.
All right. Thank you. Okay, Ms. McLean.
Thank you very much, Your Honor. So this matter has been pending for about 3.5 months, unfortunately, without any meaningful movement forward on even just temporary orders. Mr. Rodriguez was served at that time in the state of Florida on June 16th, and we were scheduled for a hearing originally on July 11th. Mr. Rodriguez had filed a request to extend the hearing date, and if I recall correctly, we were in front of Commissioner Carmi at that time, and she agreed to continue the hearing date to August 29th. And at that time, she also reserved my client's request for retroactive application of the financial request for child support and child-related expenses. When we were scheduled to come into court on August 29th, I had received a notice of appearance from counsel, and then it was agreed that we would continue the hearing to today's date, provided that Mr. Rodriguez's reply documentation, if we weren't able to work out temporary orders, would be submitted to my office no later than September 5th. On that date, or shortly prior to that date, actually, I think I received the withdrawal from counsel, and I did not receive any responsive documentation from Mr. Rodriguez until September 18th, which was about 7 days after he had filed documentation with the court. So I lost a whole week there as far as documentation. When Mr. Rodriguez had not submitted documentation by September 5th, I did provide an updated declaration to the court from my client for today's hearing, which we filed on September 14th, just sort of outlining what has occurred, as there had been some substantial changes that had occurred in Mr. Rodriguez's life and whatnot, compared to what we had initially filed with the court. And I felt it important for the court to be aware of those significant changes. So we are now here trying to get some temporary orders in place that should have been in place a couple of months ago. As my client tells you, these parties separated in March of 2023. And at that time, Mr. Rodriguez chose to move to Florida, where he lived with his family. And my client and their child, Avery, who had just turned 1 around that time, had remained in his parents' rental home here in the local area. And so at that point, Mr. Rodriguez had made the decision that he was going to move himself away, a significant period away from his child and obviously from the relationship. I do note that in Mr. Rodriguez's responsive documentation, he does attempt to argue fault. And I would simply object to the court taking into consideration any type of marital fault in making determinations and orders today. What is most telling, I think, is the fact that he did make that decision to move away from his young child. Clearly, Ms. Rodriguez has historically been the child's primary parent. She talks to you about circumstances and incidents during the relationship that involved Mr. Rodriguez yelling at her in front of Avery, throwing items at her and damaging personal property and flooring because he had thrown things so hard. She talks to you about his denigrating her and calling her foul names on social media. And then she also talks to you about the very few instances where she attempted to rely on him to solely care for Avery while they were together. And his calls to her shortly thereafter to come back because he could not handle caring for the child, did not trust himself caring for the child, and was afraid that he was going to do something that he might be sorry about. And that frightened my client. Obviously, as an educator, she's engaged in a number of classes and courses involving child welfare and child education and development. And she saw that as a huge red sign and decided that that would be the last time that she would attempt to engage the child and his father one-on-one. So now we are at a situation where their marriage, unfortunately, has resulted in them separating. Mr. Rodriguez making the decision to move, 2,000 miles away from his infant child. And I think that that speaks volumes to his idea as far as parenting. My client, since he has moved back, has been cooperative with him as far as scheduling visits that she could supervise. And she tells you in her supplemental declaration that we filed earlier this month that she's not opposed to his Aunt Becky supervising visits. She feels that they would be on the same page in ensuring that the child is protected. But the suggestion that Mr. Rodriguez proposes about having a week on, week off, I think clearly shows that he doesn't have a clear understanding of child development and what is in this child's best interest, as it's certainly not in any developmental study in the child's best interest at this age to remove him for a week at a time from a primary parent, which that has only been his primary parent since he's been alive. Originally, so we did not request a guardian ad litem at the time. Obviously, he was across country. We expected that he would be traveling here to exercise visitation as agreed upon between the two of them. Now that he's back here and in light of the anger issues and the name calling and things like that, I guess I would leave that up to the court's consideration as to whether or not it would be appropriate to appoint a guardian ad litem in this case. Certainly, we aren't going to be able to get any place from my perspective, given the history of how this case presents at this point, to agreeing to any type of a joint custody. And quite frankly, I see that more as an effort to reduce his financial obligation towards his child, rather than really looking at meeting the child's best needs or continuing any type of historical contact and relationship that was established previously. And again, that's coupled by the fact that he removed himself from the child's life for about 6 months in the last year and a half of this child's life. So we're asking the court to adopt our proposed parenting plan that essentially provides for visitation with him as they can agree. And those parameters at this point, my client believes that those should be supervised by either herself or his Aunt Becky. If the court deems it appropriate, then perhaps we need to appoint a guardian ad litem now that he is back in the local area. If you do appoint a guardian ad litem, and this sort of dovetails into the financials, Mr. Rodriguez has not provided any financial support in hand to my client. He did arrange for his parents to lop off $500 a month on the rent while she and the child remained in that family rental here until she relocated to a new rental, but that didn't really give her money in hand. And so he's provided no financial support. We would ask that the court take that into consideration if you do appoint a guardian ad litem, as far as allocating that guardian ad litem order. And I would suggest somewhere along the lines of a 25% obligation to my client and a 75% obligation to Mr. Rodriguez. As we outlined in my client's declaration, she is a teacher. Mr. Rodriguez points out in his reply declaration that she does have her principal credentials. She does have principal credentials and her master's. She's already receiving elevated pay based upon her years of education, because there's a union scale for that. She has, in fact, applied for 15 different administrative positions. She has never received an interview for any of her applications. So the suggestion that she is a deep pocket that Mr. Rodriguez wants her to be is not factually accurate. Her income is what it presents as we filed under her sealed financial source documents. And keep in mind that for purposes of child support, there are only certain allowable deductions in calculating net income. So when you do that, her net income is approximately $4,300 per month. But when you take a look at her overall contract and then the fact that she's covering health insurance expenses and has other mandatory deductions that are required under her union contract, but not allowable under the child support calculations, her actual net in hand is about $3,800 a month. And I think that's significant when we're talking about what to do with the financial circumstances or the financial requests that she has posed to the court. During their marriage, they had community debt that was consolidated. And as you can see from her financial declaration on page 5, that personal loan is almost $13,500. And she pays $500 per month on that community obligation. She also has student loans that have now come out of deferment, and she pays $200 per month on those. And there are two other credit cards that, I believe two or three other credit cards that she pays on average about $325 a month for minimum debt payment. And then we have daycare. Daycare is $45 a day for in-home daycare. So it's running her about $900 a month. Mr. Rodriguez has not contributed towards that. He's not contributed towards uninsured healthcare expenses for the child. He's not contributed towards insurance expenses for the child. Currently, my client pays $246.50 a month to cover the family on her health insurance. From that, $121 is the cost to cover Mr. Rodriguez, And we had requested in the temporary orders that she be allowed to remove him from the health insurance because at that time he was residing in the state of Florida, and we did not believe that Florida would recognize her Washington insurance. And so we wanted to be able to at least save that $121 per month. At this juncture, I don't know if Mr. Rodriguez has healthcare benefits available to him through A. So I don't know if that would be appropriate for him to access that through his own employment so that my client could remove him from the insurance even though he's moved back. So that's sort of an unknown as I sit here currently. My client also pays $73 per month. Of that $246, $73 a month is attributed for Avery to be covered on her health insurance, and that's included in our child support worksheets. For purposes of Mr. Rodriguez's income, he was, before he moved to Florida, working at A. It's my understanding that he is back at A. He works Wednesday to Sundays from 5 a.m. to 2 p.m. And so again, when you're considering parenting plan issues, obviously 5 a.m. start time is not conducive to certain exchanges and visitations and the like. In any event, I have his net income at approximately $2,800 per month, and that was utilizing his prior income of $19 an hour. I don't know where he's at. I have not received as far as a current wage stub from him, so I don't have any independent verification other than the prior historical financial records that we submitted under sealed financial source. Mr. Rodriguez has minimal debt. He had one credit card that he was paying for, and it was maybe like $1,100. And other than that, he had no other community debt that he was having to pay for. So we are asking the court to enter child support at $489.74 per month, and that he pay 40% of uninsured healthcare expenses, work-related daycare expenses, school-related daycare expenses if my client has to go to continuing education and the like, preschool expenses, as well as extracurricular activity expenses. We are asking that these commence retroactive to May 1, 2023, because as indicated, even though they separated in March, there's been no financial support from him, and my client has been trying to foot the majority of the community debt without his assistance. I would also note that this is essentially our third court hearing just to get temporary orders entered. Obviously, there's a cost every time that I have to appear on behalf of my client. I think it would be appropriate for the court to award some temporary attorney's fees of $750, which I would need to include in an updated temporary order to the court, as well as a guardian ad litem appointment order if the court decides to do that.
All right, thank you. Mr. Rodriguez Tesser, any response?
Yes, Your Honor. Actually, quite the response, actually. Bear with me. That's a lot to unpack here. So what I want to say here is that the opposing counsel has got it all wrong. How everything has happened has not happened in exactly that light by any means. Me and Rebecca agreed verbally. And I even asked her for a written agreement if she would like. She declined me. I asked her if we could, I could spend some time with my family, if that would be a difficult situation for her, emotionally or whatever. I asked many times, and she said, I think it would be best that you left. And so I did. That's what happened there. I went to be with my family in Florida because I had no other support here in Washington. Don't have any real friends to rely on. I don't have anywhere else to go. So I went to be with my family in Florida. That was not a decision that I made lightly. It was certainly not a decision that just I decided to leave the next day. It did not happen that way. As far as any kind of verbal disputes that Rebecca and I have had, that is categorically false. I'm not throwing things at her. I am not yelling at her or obscenities or talking about her through social media by any means. Yes, I've made some posts on social media regarding how I feel about the divorce, but never have I ever named her in those posts, and I have never talked about my divorce in detail on posts with anybody. So there's that. As far as the financial support, I have given financial support in many different ways. I've given her a lot of our community property, such as couches that we bought together, any kind of furnishings that we bought together, a TV, all those kinds of items that are fairly expensive. I have asked her on many occasions if there's any kind of way that I can help her with anything that she needs. I've been declined. I don't know if there's a process in which I can prove that. Unfortunately, I don't have documentation to prove that, but I will say I have made many verbal attempts to ask my ex-wife what I can do to help her in any way, whether emotionally or financially. So that is false from Miss McLean. Another thing is that I don't agree respectfully with a GAL. And the reason why is because I believe it's a financial strain. From what I understand from my prior lawyers, it's a financial strain for both her and I. I believe that takes away from this supposed financial issue that we're having if we're just continuously dishing out more money for things that aren't really necessary. Rebecca and I, when we're together with Avery, we are a pretty good team. I would hope that she would agree to that. We're a pretty good team. We have really good visits together. Every time I try to visit at least once a week, as often as I can. As far as me being in Florida goes, I came back on my own admission. I could have stayed in Florida, but I decided that it would be best to be in Washington, in my home state. I now live with an uncle of mine. I have some extended family members, people I don't really know. They're on my father's side, on my stepfather's side, excuse me. So I don't know them that well, but I do know my uncle, and he's been very helpful in helping me through this. And as far as if there's anything else I'm forgetting here, yeah, I feel like I've made every attempt that I possibly can make as far as what I can do for Rebecca, and a lot of it's been declined or ignored. As far as what's been written about me in the declaration, I find it very hurtful, actually. And I feel that over the course of Avery's life so far, I've always been readily available and eager to help in any way I can. And yes, I make mistakes. I am a parent, and I'll be honest, I make mistakes. And I think every parent makes a mistake. I don't think that is a bad thing. I think that through mistakes, you learn, and to be a better parent. If you can't make a mistake, then there's really no reason to be a parent if you can't make mistakes and learn from them. And that's essentially what I've been doing and have been correcting as well. So that's false. I have been there. I've always been there. I'll continue to always be there. I am eager even still to this day to help in any way that I can. If that means Rebecca is feeling secure, I would ask the court that if they're going to want me to pay, I know the first hearing they asked for $1,000. I'm not really sure why this number. I don't know what the difference is between 1 month to the next month, whether I pay or not. Is this going to be a every monthly thing? I'm not clear on that. And then, of course, if they're wanting $745, I think it is, or 89, or I don't remember the exact number. I'm sorry. But I would like to itemize, have an itemized receipt of expenses that she's doing, because, I'm struggling just as much as she is. I might not have Avery in my possession with me, but that doesn't mean I'm not struggling. She has a very nice home with a lot of space. She has a very good job that gives her regular yearly raises. She has the ability, she has a degree, as opposing counsel says, she has the ability to get a better job at some point if that's something that she's determined to do. I have backed her up on all of those things, even while she has gotten her master's degree. I have backed her up. I have supported her. As far as any community debt, I have never been aware of that. I've even asked Rebecca if there's any debt between the two of us that I need to be aware of now so that I could help her with that debt. There has been absolutely no attempt to ask for money in that regard. And I just haven't seen that. So I guess until there's a correct amount of communication with her and me, there's not much one can do when nobody is talking about it, actively sitting down and talking about it. I have made many attempts with opposing counsel and the petitioner to mediate, to figure out what's going wrong, how we can solve this, and why. That hasn't happened. There's been no appointment. We've not set an appointment to do that. I've been ready pretty much every day, if they wanted to. Nothing has happened in that regard. Now, as far as my lawyers go, I had to let my prior lawyer go because of the financial strain. Of course, just like the opposing counsel, I did not realize that this would go on as far as it would. And so it has caused a financial strain. It has caused an additional debt. I do have debt in my name. It is not minimal by any means. And so I think I have about $60,000 in debt from school loans. And of course, an additional almost $10,000 just from using the lawyer. And of course, my response to Ms. McLean, the declaration, yes, I did fail to get that in on the 5th. I take full responsibility for that. I will give you a reason why that happened, just real quick. The real reason for that is not because I didn't want to do it, not because I didn't have the ability to do it. What happened was a kind of a miscommunication, almost a mishandling of my case, I believe, from my prior lawyer. She did not give me the documents I had asked for to take on this case on my own.
I would interpose an objection. I don't know how that's relevant at this juncture, and it's certainly far afield of his declarations before the court.
Why don't you get to your conclusion, sir?
Yes. Well, I think it's very relevant. But anyway, the relevancy is that I'm just in financial strain as she is. I mean, you've made that argument, so I'm reacting to it. So, I think I've made some very fair attempts. I see that opposing counsel is making very drastic steps. I think we could easily make this a forward situation, and it hasn't happened. This is completely on them. It's not on me. Like I said, I'm ready to figure this out today. If you wanted to, I'm always open to that, but it hasn't happened. The response has been aggressive. That's it.
All right. Thank you. Anything? Well, do you have insurance with your job at A&A?
Oh, no, Your Honor, I do not.
Are you eligible for insurance through that position?
I am, yes.
So you could sign yourself up for insurance?
Yes, correct.
Okay. Thank you. Ms. McLean, briefly.
I would just note that he's been aware of my client's financial request since being served with our proposed orders and the initial pleadings in this matter in June of 2023. While I appreciate Mr. Rodriguez's request as far as communications and the like, behind the scenes, he's left messages demanding that I tell him certain things. And I, as the court knows, I'm not allowed to give him any legal advice. He had an attorney. He needs to seek out other counsel or other avenues for advice, because I cannot give him legal advice on what we have forwarded to him and pending motions and the like. So I just simply want that on the record, that I cannot do what he's demanding of me to do. And I think that his tone in the case is just the tip of the iceberg. It's what he is demanding. It's everybody else's fault. And you have a two-mouth household that's trying to survive now on one income. And my client needs a financial assistant to help support their child that they have in common. So we're simply asking that the court adopt our proposed orders.
And I didn't see, and maybe I missed it. Did you have access to his financial statements or something from him when you did the child support orders?
So when I filed the sealed financial source document back on, bear with me, that was filed back on June 12th. I had a copy of his wage stub that was dated April 7th that I used for purposes of child support. That's the attached page 2. And I had his, so let's see, his hourly rate was $19. And I believe that that's what I ran him at, even though he does get a shift differential and an overtime. But if you give me just 1 minute, I'll refresh my recollection. So if you take $19 an hour, 40 hours a week, 52 weeks in a year, and divide by 12, that provides a gross of $3,293, which is consistent with what I've provided in the child support calculations. So I arrived at a net for him of $2,803.
Okay. So I think it's appropriate to get some of these temporary orders entered. I appreciate that there may be a move or a hope that this can be resolved quickly and through negotiations, but it's always good to have temporary orders in place. And clearly there's a need for some financial orders specifically in place. And that way everybody knows what's expected and what they're doing. So I have reviewed the child support worksheet. I'm gonna enter that as presented. And then coupled with that, the child support order with child support set at $489.74 a month. I'm going to set that to start 8/1/23 and not 5/1/23.
Would the court reserve the ability to request?
Yes.
So I don't know if you want to interlineate that at paragraph 11 or the last paragraph. And if you'll give me just a moment, there's just a statute that I would ask you to cite, but I have to look it up. So if you would just indicate that you're reserving jurisdiction for child support pursuant to RCW 26.26B as in boy, 0.040.
I've included that on section 11 on page 3.
All right.
And I think the proportionate costs, so Mr. 40, Mrs. 60 is appropriate. I would ask Mr. to get himself on medical insurance, and I'm going to set a 60-day time frame to get that done and provide notice that you've enrolled yourself in your own medical services. So that essentially will provide some savings to Mrs. As to the temporary family law order, I haven't, in reviewing the response, I think all parties are responsible for debts moving forward, their own property moving forward. That a lot of that clearly seems to have been kind of taken care of before here. Petitioner is going to continue to assume the Nelnet student loan, Upstart personal loan, Capital One, Bank of America, and Synchrony loans. Respondent has his own student loans, as he indicated, and a capital one, debt that's unknown to the petitioner. So those, I will sign the temporary family law order.
So if Your Honor, given your ruling about the 60 days on health insurance, would you mind interlineating that at 11A? And while she's doing that, Mr. Rodriguez, I will be forwarding you a conformed copy of the orders after they're available to us online.
Okay, thank you.
And so what I indicated on here under 11A, I struck the due to the move to the state of Florida. I said and that he can remove from health insurance coverage through her employer in 60 days or upon notice from respondent that he has enrolled in his own health insurance. So I guess Mr. Rodriguez Disser, if you can do that in 1 week and you notify her, then she can remove you early. If you haven't done it within 60 days, then you're not going to have insurance. So
would you mind adding whichever occurs first to that interlineated language?
As to the parenting plan, it sounds like there's been visitation that's occurring since he's moved back home and that they're able to work together on that. Is that fair? I'm getting a lot of head nods. Okay. Because this order clearly, I think, was written up when he still was in
Florida.
I'm gonna, and there's no allegations of 191 factors. I am gonna switch there's no reason to limit decision making, so I'm gonna make that joint. As for the parenting schedule, it does allow some pretty free reign between the parties. I don't generally like doing that, but it seems as though so far that's been working out. One thing I do want to really just kind of touch base on, it says agreed upon 30 days. So that's likely considering flying from Florida to Washington all the way across the country, which no longer is the thing. I guess I would ask the parties, have you gotten into some kind of a routine, or is it change every week, or either, whoever wants to weigh in?
I could speak to that, Your Honor. It's been varied based on our work schedules and just the schedules that Mr. Rodriguez and I have. I'm happy to make a more solidified and consistent schedule. I think that would be good for both us and for Avery. The concern that I have is that if we do move forward with a more solidified schedule for visitation, that I would like at least a period of time at the beginning of that schedule for a certain number of visits to be supervised by Becky, his aunt, if I am not physically there myself.
So all the visitations thus far, the whole family's been together, essentially.
Correct.
Okay. So here's what I'm going to do. On B1, line 16, I'm going to say at such other times and locations as agreed on between the parties, period. And I'm just going to strike the remainder of that paragraph. How many visitations do you feel like she needs to be at if you're not there before we can move to Dad being able to do visitations on his own?
That's a good question. My main concern is that when we are together as a family unit, if you will, Avery, or really if I'm with anybody else, Avery's really quick to come to me if something goes wrong. And I'm really, just all things considered, with Mr. Rodriguez's prior lack of confidence in his parenting when I'm not present, I would just want to essentially just kind of have that insurance that he's building those skills so that when he is alone with Avery is confident going to him for something that he needs, but also that Mr. Rodriguez is confident in caring for Avery. So whatever the court deems appropriate is fine with me.
Okay, barring any, I mean, I guess there are some concerns raised. They don't rise to the level of, limiting Dad's interaction or anything of that nature. So I basically just kind of put some parameters, and it sounds like this is an area that you all are working well together on, and I really appreciate that. So what I've indicated is If the petitioner is not available for scheduled visitations, that Becky Hornis is an agreed supervisor for visitations for a minimum of 4 visits, a maximum of 8 visits before the respondent will get visits alone. So that gives you kind of an integration time period to have some assistance, a buffer, however you want to phrase it. And then hopefully that'll get everyone to a place where you feel confident handling those kind of issues alone. Okay.
Is the court willing to consider also including some requirements for him to participate in some parenting classes?
I think there's a lot of really great online parenting classes, and it probably wouldn't be a bad idea. And if that's an area that Mr. Rodriguez has indicated, you know, that it's a huge learning curve. I'm not, I can only imagine. So I don't think that it's probably inappropriate. So I would recommend that, Ms. McLean, if you put me on the spot, normally I can rattle off a few.
So obviously with the divorce, the children in between class, I think would be appropriate. Also, there's through the Parents Place, they have both in-person and online classes, which would include such as the active parenting class. There's also, let's see, I think it's children 1, 2, 3 are growing up. Let me look here real quick. There's the Strengthening Families program, but that may be for older children. The Incredible Years. The Incredible Years is also a good parenting class. And those are age-based. And so he can pick the class that is appropriate for Avery's age.
Okay. So, Mr. Rodriguez, I'm gonna ask that you take either the Children in Between or the Incredible Years class. I think there may be even other options, and I don't know if there's costs associated with those. So I can appreciate that. I'm not going to include it in the order, but it's I'm highly recommending it. And if I have to make it part of the court order, I will. I'm not going to do that at this point. So hopefully you'll take the initiative and do that at this point. Based on the court's suggestion. And frankly, it's probably good for parents that are all of a sudden now parenting alone to get as much information as they can. Okay, so I've made the changes that we discussed to the parenting plan. I've signed all 4 of those documents. Those should probably be available to the parties by tomorrow afternoon through Odyssey. Any other questions or concerns?
Was the court going to refer this matter for guardian ad litem investigation, and were you going to consider an award of fees?
Guardian ad litem at this point, no. I think there's no allegations that are, I think, concerning enough. They're willing to appreciate each other and work together on visitation, even with no parenting plan in place. So I don't, at this point, see a GAL as necessary. And there was a request for the $750 in attorney's fees. I'm going to deny that at this time, but obviously that's something that can be reserved.
Okay.
Right.
All right. Thank you.
All right. Good luck to everyone. Thank you.
Your Honor, before you leave the court hearing, I just wanted you to be aware that Ms. Height on our matter involving the Fisher matter emailed me, and she indicates I made an error in my report of Mr. Fisher's fee paid. He made a second payment on March 30th of $900, so no further payment is required. Thanks for mentioning that. Judge Fassett had moved on in the docket before I noticed the second payment on the next page. She said she'd figure her hours by the end of the week and see if there's a refund due and get that to me if appropriate. So the ex parte order that I'm going to send over on that case is not going to include that judgment, but it will include the discharge of her services.
Perfect. I appreciate the update.
Yep. Thank you.
All right. Thank you. Good luck.